Good morning. Thanks everyone for joining us. I have the easy part in all of this. So, the attorneys have the tough part in all this, and Jeff, he's got to run everything. So I just wanted to introduce myself. I'm Diane Skinner. I'm one of the directors for Artemis Lifestyles. We are a full service management company. Our main office is in Kissimmee, Florida, but we cover all of Central Florida. We cover all of the West Coast. I'm located in the Tampa market, and we cover East Coast. We don't cover South Florida right now, but pretty much everything else in Florida we cover right now. So if you are in need of a management firm, please let us know and we'd be happy to speak with you. Um, Otherwise, I'm going to let you go back because this is a really long course. So I'm going to let you go back to Jeff.
Thanks, Diane. It's always great to see you. So again, thank you for
Thank
having us today, for collaborating with us. Uh, the second half of today's program will be taught by Kerstin Henze. She is our managing attorney over in the Tampa West Coast area of Florida. And before Kerstin goes away for about an hour and a half, say hi to everybody, Kerstin.
Hello, everyone. Thanks, Jeff. Hi, Diane. Hi, Alan. Thanks, everyone, for spending your Friday morning and afternoon with us. Again, I'm Kerstin Henze, and I'm a partner and managing attorney of the West Coast office for the firm. For those of you who are not familiar with the firm, we are an exclusive community association law firm. That means that we represent exclusively condominium associations, homeowner associations, and then cooperatives as well. Our main office is located in South Florida in Pompano Beach, but we do have other locations, including Palm Beach Gardens, Orlando area, which Alan's going to speak about, and then obviously here on the West Coast in Tampa. I have been with the firm since 2010 and practicing law for much longer than I thought I would.
We all started when we were 8 years old, let's just say.
All right, so I will, Alan's going to start, and then I will come back in an hour and a half to 2 hours to teach the latter part of the course. So see you soon.
See you soon. And before we introduce Alan, I just want to mention you do not need to go into the Q&A and say, hey, I'm here. Can you see me? If you're here, you can see us and hear us, and you see your name showing up on there, you're good. You do not need to do all that. Your unique attendance link is your sign-in. There's nothing to sign in with. That is your unique login. If you're here, you are good. Just if you're watching in a group, that's the thing, okay? You just must be here individually. That's, hope I'm making sense. So with that said, I want to now introduce our instructor for the first half. This is Alan Schwartzseid over from our Orlando, Central Florida location. He also started when he was 8. Alan, how you doing, man?
I'm doing okay, thank you. Yeah, let's just go ahead and say I started with the firm in 2010 as well, but I had a brief hiatus and now I've been back for about 3 years. So let's just say I started when I was 8 as well, just like Kerstin. So as a preliminary thing, I think Kerstin handled most of the information about the firm. The other thing I like to mention when it comes to our firm is, we've been around since the 1990s. We've got 23 attorneys, 8 of whom are board certified in this area of law. When Kerstin says we are exclusive to the representation of homeowners associations, condos, co-ops in Florida, that's really true. It's really our only focus of the entire firm, whether it be an attorney in my office in Orlando, which is really Winter Springs, just to be clear, or in South Florida, or in Kerstin's office in Tampa. This is all we do. And when I say this is all we do, it's not entirely accurate because we also represent associations in litigation. Now, that includes having a board certified construction attorney on staff in the Pompano office. So really anything that comes up, I'd say 99% of anything that's ever arisen that an association needs, we've probably handled it 100 times already. So without further ado, and I can talk about myself, but bottom line, I manage the firm's Orlando office. Again, I've been with the firm on and off since 2010. I was here for, thank you, Jeff. I was here for 4 years, starting in 2010, and then again had a brief hiatus, and happy to be back with the firm since 2022. So anyway, as Kerstin mentioned, we've got a ton of information to get through. So let me go ahead and share. Hopefully this will work correctly. And Jeff, if you can just confirm that you can see the PowerPoint.
Yeah,
Perfect.
we're good.
All right. Well, without further ado, we'll go ahead and get started. As Kerstin and I just mentioned, we've got a ton of material to cover. I'm going to try and go through the information, which is what you're supposed to be getting, and also some practical tips that are actually helpful, which the materials are as well. But in reality, the things that the DBPR and the state want you to know are not everything you need to know. And frankly, if I went through just the statutes and the law, you still wouldn't have a great understanding of these things. So I'm going to try and get a little more practical, speak in some plain English, and hopefully you guys will understand and appreciate a little better.
And I'm
So
going to
just
mention, Alan, real quick,
good.
which I failed to mention, pardon the interruption. You do not need to take extensive notes. After you fill out the evaluation at the end, we'll put that link into the chat, as I mentioned earlier. And after you submit the evaluation, there will be a link to download and save these slides. So you can just watch, pay attention, and don't worry about taking crazy notes. Back to you, sir.
All right. The other thing I'm going to mention again before I actually get started, it's in my face right now. This class is not for HOAs. So if you are in an HOA, this is your chance to not spend the next 4 hours with us. You can come back in a couple weeks for a 3-hour HOA course. Sorry, condo folks. Sorry, co-op folks. The state decided those timelines, not us. All right, so if you need to contact Kerstin, if you need to contact me, or frankly, if you just want to contact one of us, our information is right here on this first slide that, as Jeff just mentioned, you will get after you complete your survey at the end of this class. So again, you don't need to be taking copious notes. You might want to add some of the materials that I'll talk about and that Kerstin will talk about that are not directly in the slides, but there's no need to sit and write down every single thing that we're going to say. All right, so jumping into it, you've got some information regarding Kerstin, regarding me, and before I truly get started, for the 5th time that I've said I'm going to do it, I do want to go ahead and thank Artemis, thank Diane for having us co-host today. They do a great job. I've never had any problems with any of their managers or their teams, so happy to partner with them today. All right, topic 1. Milestone inspections and structural integrity reserve studies. Now, I'm going to let you know this is some of the most boring information that you're going to get today. However, it is crucial for most communities, most condos and co-ops in the state of Florida. We'll talk about some limitations on who this applies to, and then we'll go through some of the information. But I want to thank Kerstin for letting me go first so I can be with my family at this afternoon. My kid's birthday is this weekend, but I also want to say she could have just said no so that I didn't have to cover this information. But we're going to get through it. It's going to be somehow fun anyway. So here we go. Milestone inspections. So the first thing I want to talk about is what the heck is a milestone inspection? Hopefully, everyone that is taking this class has at least heard that term before. If not, it's essentially a visit to your buildings to take a look and see, are there any structural issues that affect the integrity of your building? That's really all this milestone inspection is. That's phase 1. Someone who's qualified takes a look at your building, make sure it's safe. That's it. So what is it? We talked about what it is. I'm not going to go through the primary structural members and systems because realistically, your person that's doing this inspection is going to know what they are and you don't have to know. The people that can perform this is important. An architect, an engineer, both licensed in the state of Florida, or a team of professionals with an architect or engineer acting as the design professional that is responsible for everything that goes into the report. Now, I say the report, you're going to say, what report are we talking about? The whole purpose of this inspection is to end up with a report that says either the building is safe, we see no problems, or the building might not be safe. We need to move on to what's called phase 2 inspection. We'll get to that in a minute. So the report is basically a document that says whether your building has any structural issues or not. The purpose of this is not to determine whether you're sitting here and everything in the building is absolutely perfect. It is purely to attest to the life, safety, and adequacy of all the structures of your buildings. Okay, you're going to determine the general structural condition as it affects building safety, including determining what maintenance, repairs, and replacement of these structural components might be needed. That's all the information that's going to be in this report. Okay, again, not determining whether the condition of the building is perfect or whether it is compliant with the Florida Building Code or the Fire Safety Code. So you can have a non-compliant building that still passes muster on this phase 1 inspection. Do we need it? Now, I said we were going to outline some exceptions to the requirement to have this inspection done. If your building is not 3 stories or more in height, as determined by the Florida Building Code, and subject to a residential condo, you do not have to have this. So purely commercial buildings won't need a milestone inspection. Single family, 2-family, 3-family, and the addition this year's statute was 4-family dwellings with 3 or fewer habitable stories above ground do not need to have this done. Now, the fact that you don't need to have it done doesn't mean it's not a good idea anyway. If your building is 30 years old, you should probably get something looked at. Okay, presumably all along you've had it inspected at some point. You might have gotten a reserve study done that might accomplish some of the same things as what we're talking about here. But the bottom line is, even if you're not required to have it, you might want to consider it anyway. And again, 3 stories or more, residential condominium or co-op are the ones that need to get this done. Mixed use and condo hotels, it needs to be arranged by the residential condo owner association and any owner of a portion of the building that isn't part of that residential condo. This is when we get into, again, condominium hotels, mixed use properties where you've got a downstairs that is operated as retail and all of the upper floors. We have some of this in Orlando. I know there's some of it in South Florida, some of it in Tampa, where you have all of the upper floors are residential, but the bottom floor is still part of that same condo, but it's not residential. Okay, that's going to fall into this category here. Each are responsible for ensuring compliance. So just because your portion that you own is not the residential part doesn't mean you still don't have that responsibility to make sure this is done. The condo association is responsible for all costs attributable to the portions that it maintains. So what we're saying is the portion of that study that is in the example I gave, the residential portion that's floors 2 through 8, whatever it may be, that's the portion that the association is responsible for. The owner of that separate physical area that the association doesn't maintain, doesn't repair, doesn't replace is going to be the responsibility of that owner to have that milestone inspection done. Now we're talking about fiscal responsibility. So usually you're going to have one study done and split the cost, but you don't have to. When do we need it? It's by December 31st of the year when the building reaches 30 years of age. Okay, the date that we're looking at to start that clock running for 30 years is the date the certificate of occupancy was issued for the building. Now, in certain counties, there have been floods. There weren't always digitized records. So that record might be lost. It might have been destroyed 30 years ago because you might have a 60-year-old building. If that's the case and you can't find the original certificate of occupancy, what you're going to use is the first CO that you can find in the county records for any unit or any portion of that building. Now, there are different timelines here. So if the building reached 30 years of age before July 1st of 2022, that initial study was supposed to be done by December 31st, 2024, basically the end of last year as of this recording. If the building reaches that age after July 1st, 2022, and before December 31st, 2024, you were supposed to have it done by the end of this year, 2025. If the building reaches 30 years of age later than December 31st, 2024, you go by 30 years. Another milestone inspection after you've performed this first one and you've done everything you need to do is done every 10 years. So this is not a one and done project. It's every decade. Now, again, I mentioned you might want to get it done more frequently. If you see problems popping up with the stucco on your buildings, where your balconies have spalling or you're starting to see them crumble, whatever the case may be, if you see any problem with the structure of your building, it might be time to update at least that portion of the inspection report and maybe even go on to phase 2. Now, the local enforcement agency, which is usually your code enforcement department or the fire department, not necessarily fire, but that type of code enforcement, can require that the initial milestone inspection be performed by December 31st of the year when the building reaches 25 years of age. It used to be 30, but they can basically make you do this a little early based on local circumstances. Now, those local circumstances could include proximity to salt water, or really anything else according to the statute that local enforcement agency says, no, we think you need to get it sooner. Those local conditions could be pretty much anything. So basically be on the lookout for notices from those local enforcement agencies once your building hits 25 years of age. And then again, even if you get it done after those 25 years, that doesn't mean you can wait 15 years because you should have needed it at 30. It still means you only wait 10 years before you do the next one. Now, that deadline that I mentioned in the last slide, that deadline can, not must, but may be extended by the local enforcement agency if you can show that you've actually entered into a contract with a either an architect, engineer, or a team operating under those people that says that basically they weren't available to do this study within the time you had. That doesn't mean wait until a week before to start shopping for bids for this project to be done. You should be shopping for bids at least a year before this is due, in my opinion, because there are only a limited number of people who are capable and willing to do this. So, there is a lot more labor than there was before the change in the statute that allowed people who are not architects or engineers to do this work. There is still a little bit of a delay in getting this done. Most engineers and architects and teams that I'm hearing of are at least a month and a half out. So if you wait until 6 months before, you're probably waiting too long. So bottom line, if you need to get it done, because it is important to know that your building is structurally sound, especially one that's at least 25 to 30 years old. The other thing to keep in mind, this statute is in the process of potentially being revised this year. I won't go into the details, but they are looking into making it easier to get these done, to do the work that you need to do if it's something that this architect, engineer, or team tells you you must have done. And that pertains primarily to how you're funding these projects once you're told that you need to have it done. So I won't go into detail because who knows what's going to pass. My favorite law professor's line was, nothing is safe when the legislature is in session. So this law that we're talking about, the bill that's out there right now, could pass, it could not, but I do want to make sure that people are aware at least that it is in process right now. Milestone inspection reports that were prepared before July 1st, 2022, meaning before this law came into effect at all and no one knew that you would ever have to have a milestone inspection. Okay, well, if you've had that inspection done before this particular date, the local enforcement agency may, again, not must, but may accept an inspection report that was prepared that meets the requirements that if you were have it done now, you would be okay with it. In other words, if the report that you got in 2021 meets the requirements that kicked in 2022, the local enforcement agency can say, yeah, it's okay. You can use that one. You have 10 years from the date that that report was provided to you to do the next one, instead of having to do another one 2-3 years later. Let's see. Okay. The first thing you need to do once you determine that you actually need it is provide written notice that the inspection is required to the association and the owner of any other, and this is not the association letting you know, it's the local enforcement agency. So I apologize for not clarifying. The local enforcement agency needs to provide written notice that you need to do this. That notice also needs to go not only to the association, but to that owner of the downstairs, the first floor that I mentioned in the example earlier. The association does need to notify the members after receiving that you do need to get the milestone inspection performed within 14 days after you get that notice from the local enforcement agency. And just like a lot of the things that you can send out, this can be basically a postcard saying, hey, we got to get this done. We got notice from the local enforcement agency. We're going to work on it. Now, the milestone consists of 2 phases. I mentioned phase 1, which is literally just taking a look. Phase 2 is where you've got a problem noted in the phase 1 report, and you want to dig a little deeper, whether literally or metaphorically. You're literally going to do potential destructive or non-destructive testing on the building to check and see whether there really is a structural defect, or for example, it's a crack in the paint, not a crack in the stucco. Let's see, phase 1, we talked about all this, except that a phase 1 inspection needs to be completed within 180 days after you receive notice from the local enforcement agency. So that is your timeline. You get that notice. If you haven't already taken care of this, you have 180 days to get it done. That's 6 months. Again, we're talking about people being about a month and a half to 2 months out right now if you reached out today. So make sure as soon as you get that notice, one, send it to your lawyer so that they can make sure you're doing what you need to do and give you the guidance that you're getting here today as to, and by the way, I don't think Jeff mentioned it, anything we say here today is not legal advice. It is guidance on what the law is clearly saying. Some of it might be my opinion. That is, again, not legal advice. So the guidance based on the statutes is that you are going to want to reach out to your attorney and take a look at what's in here in these slides and comply with this 180-day timeline. Once the phase one is done, that means that the architect or engineer or team who did this work has actually submitted the inspection report. That's the report that I mentioned earlier. If there's substantial structural deterioration found in any building components that were inspected by this phase one, if there are no substantial structural deterioration found, this phase two is not required. If there's any of it, even one item that's found to be problematic, that's going to be reported in phase one, and the engineer is going to let you know, or the architect or team is going to let you know, you do need to have a phase two inspection performed. Okay, we talk about substantial structural deterioration. I won't go into this definition, but you'll have it in the slides. If you want to go back to it later, just note slide 15. Phase two must be performed, as I mentioned, if there is any substantial structural deterioration. A phase two may involve destructive or non-destructive testing, and that again needs to be done within 180 days after submitting the phase one inspection report. Now, that is a progress report. So it doesn't mean you have to have phase two done within those 180 days after the phase one. It doesn't mean you have to have the work completed to fix what problems were located. It just means that you need to actually go through and have a progress report submitted by your architecture engineer. Now, my opinion on this, again, just my opinion, if this is not done, it's going to be the architect or engineer who likely gets in trouble rather than the association. You can't control whether the architect or engineer that was already contracted to do this work does the job they were contracted to do. But stay on them for those 6 months to make sure they take care of what they're supposed to do. And then the inspector who completes the phase two also prepares an inspection report reflecting what work actually needs to be done in order to cure this problem, or that they found in phase two that there's not actually a problem and everything's okay. The report for the phase one and phase two go to the association. Any other owner of portions of the building that aren't subject to condo form of ownership. Again, anything I say for condo regarding these requirements also applies to co-ops if you're a co-op out there. And then also this report goes to the building official of the local government having jurisdiction. Now, I haven't mentioned this. Usually we're talking about a city, a county, a town, whatever government officials run your code enforcement division is really where this is probably going to be reported. Okay, these are things that need to be in the inspection report. Again, you might note this later, but it's not you preparing it. It's not you reviewing it and making sure that it's code compliant, so to speak. So my perspective is it's not your responsibility to know this stuff, but the state wants us to include it anyway. The post-milestone inspection requirements, again, within 45 days after receiving the inspection report, the association needs to provide a copy of the summary, not the report itself, which is usually somewhere between 50 and 100 pages. Okay, we're only providing a copy of the summary the inspector prepares to each unit owner, regardless of what's in there. Okay, this needs to be sent by US mail or personal delivery to the mailing address, or email if the owner has opted in to receive electronic notices. Now, I want to be clear on this, and Kerstin will go into more detail later. I think this is one of hers, not mine. If someone gave you an email address for email blasts, that is not the same as opting in to receiving email notices. So you're going to want to make sure, if you've got a manager, make sure that they are on top of this. They should be already, but understand for purposes of speaking with the manager that just because you have an email address for someone doesn't mean you can just send all of your notices to that email address. Each member has to opt in order to be able to deliver notices to them through that email address. Okay, the other thing that you're going to do after you get this inspector prepared summary, post a copy in a conspicuous place on the property and publish the full report and the summary on the association website if you're required to have one. We'll get into what communities need to have a website a little later. Local government enforcement, in other words, the local government agency, the local enforcement agency can tell you you need to have the repairs done. Hopefully, you're looking at that report that says you have to have this done or your building will not be safe and getting it done without them forcing you. But the repairs need to be commenced no later than 365 days after receiving the report. Note the word that we use here, not completed. The repairs have to be commenced. You've contracted, the work has started. That doesn't mean you're done within a year after receiving the report. I've had people ask me that, freaking out. We can't get the work done in a year. Well, I don't care. You don't have to. If you can do it, fantastic, but that's not what's required of you. If the owner of the building fails to submit this proof that this work was done and there is substantial deterioration, the local government needs to review and determine whether the building is unsafe, meaning they can shut down your building. And by the way, that has already happened for 2 buildings I know of down in Miami. Whether it's happened for any buildings in other locations, I frankly have not heard of any, but I do know that people are taking this seriously in the government. And for those of you, because I didn't mention it before, for those of you that don't know why these milestone inspections and structural integrity reserve studies came about, it's a result of the building collapse in Surfside, Florida. The Champlain Towers condominium that collapsed a couple of years ago. I think it was 2021, because the 22 session of the legislature is when some of this stuff became law in Florida. And I won't comment deeply on my thoughts on whether this is a good idea or not. I do 100% support milestone inspections. If you're not getting an inspection of your building by someone that's a professional, knows what they're doing, and is capable of telling you whether there's structural damage or structural risks, I think you're negligent. That's not what the law necessarily said before, but now it pretty much says, and we talk about it right in this slide here, failure to have this done is a breach of the fiduciary duty that each director owes and each officer owes to the association. That fiduciary duty is the most important responsibility imposed by Florida law. Basically, you may not understand this yet, but the board is running a business by being on the board of a condo or co-op. You're running a not-for-profit corporation. Now, you're not running it like a business, but you probably should, because that's really what you're doing. And as someone running a business, you have an obligation to do what's in the best interest of that business, even if it hurts you. That's what a fiduciary duty is. It is the trustee's responsibility. So you're basically a trustee of the association. And we'll get into a little further of what that means later on, but it is very important. This fiduciary duty is one of the most important things you'll learn today, other than, everything else that we have to tell you. Let's get back to this. A local enforcement agency may prescribe timelines and penalties if you don't comply with the milestone inspection requirements. That's going to generally be in the municipal code or in some resolution or ordinance of the county or the city. So it's not going to be something that's going to be shocking unless you are not paying attention to what your county or city actually requires with respect to these things. Florida Building Commission is not something that you guys need to worry about with respect to this. So we get to move on to topic 2, structural integrity reserve studies and mandatory reserves. So you've always had in a condo and in a co-op certain reserves that you were required to maintain. The legislature back in 2022, again, in response to the Surfside building collapse, Champlain Towers, added this as well as the milestone inspection. So structural integrity reserve studies is basically money that you're putting away in an account that is restricted either to specific items or a pool, basically a group of specific items that you really can't use for any other purpose. Now, it used to be that you could vote to use those for another purpose. The members had to have a majority vote in the past of the people that actually showed up at a member meeting where a quorum was attained. Now, we'll talk in a little bit about some of the changes that have been made. But the bottom line is this is money being put away to make sure that when things are expected to fail in your building, specifically with respect to the structure of your building, you've got the money to make sure they can be fixed. Because that was one of the major issues. And I say one of, which is why I'm not an enormous fan of the structural integrity reserve studies, but it was one of the major issues that the Champlain Towers condo suffered, was that people kept kicking the can down the road and not putting the reserve money away. So they didn't have the money to actually fix the problems with the building. Now, the other issue, and the reason that I don't think this would have fixed the problem, is because my understanding is that the reports actually state from that building collapse and the studies that were done afterwards that it was a construction defect and not just not having the money to do repairs that actually caused that building collapse. But bottom line, I think milestone inspections are a fantastic idea. This is a good one. Let's hope that the legislature fixes some of the problems with it over the next year or so. I do know, again, that there are some proposed changes to the statutes this year that are in play. I won't go through those in detail. But what is a structural integrity reserve study? It's exactly what I just described. It's a study of reserve funds, meaning funds that you're putting away for specific assets of the association that's required for future major repairs and replacement of these specific items. Now, the reason that I won't go through exactly what they are is this catch-all that's the last bullet here. Any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000, which is most of the things that you need to repair that are major items in your buildings, and the failure to replace or maintain that item negatively affects the items listed above, meaning your structure of your building, as determined by the visual inspection portion of a structural integrity reserve study. So again, we're talking about a visual inspection to determine how long each component of your building that is a part of the structure is going to last. So that's really what a structural integrity reserve study is. Do we need one? The requirements for whether you need this or not are very, very similar to those for a milestone inspection report. And the logic behind that is apparently the legislature is looking at it as, well, if it's a 2-story building, if it's, not really 3 stories, the likelihood that that building collapse is not going to be obvious in advance and the work is going to be done to fix it is low. And the likelihood that that building collapse is truly going to leave people from the 20th floor dropping down and having no chance of survival is also minimal. So I support not requiring this for smaller buildings, but let's get right into it. A residential condo, again, residential or co-op, must have a structural integrity reserve study done every 10 years after the condo's creation for every building. This is not the condo in total. This is each building on the condo that's 3 stories or higher in height, determined by the Florida Building Code. Now, we've got some exclusions. Again, buildings less than 3 stories, single family, 2-family, 3-family dwellings with 3 or fewer habitable stories. Any portion of the component of a building that's not part of the residential condominium. Any portion of the building maintained by a party other than the association, meaning if a unit owner maintains windows that are on the outside of the building, not part of a structural integrity reserve study, because it's going to be the owner's obligation to fund that repair if something goes wrong with that window. And again, commercial condos are not subject to this. Again, this is based on a visual inspection of the property. There are certain things that it needs to include, which it will, because you're going to use someone that knows what they're doing here. Now, let me go back. It does need to provide a reserve funding schedule. So this is the whole purpose of this study, is to figure out what are you going to need to put away in each year going forward until you actually have to repair or replace these individual components of your building. So it's probably going to say for each component what it is. So it could be your roof, it could be your AC system, whatever it may be. Then it's going to say, again, roof, what is the component? How long is it expected to last? So are you going to need that major repair in 10 years or 20? And then finally, it's going to say what that repair or replacement is expected to cost at that time. Okay, so that's really what the study is going to say is, here's what you need for each one of these aspects of your condominium or co-op building. Who can do it? Very similar, okay, but it's an architect engineer And rather than a group operating under them, here it would have to be a person certified as a reserve specialist or professional reserve analyst by CAI or the Association of Professional Reserve Analysts. Now, what qualifications are required for that? I have no idea. There are people that are reserve analysts and they are qualified and they do a great job. There are some that frankly are not, and I'm not naming names here, and don't ask me to because I won't. But moving on, let's see. So timing wise, at this point, pretty much everyone is required to do this already. You should have already had it done if you're required to do it, because it's by December 31st, 2024, which date has passed 5 months ago as of this recording. If you existed on or before July 1st, 2022, if you didn't, and your condo or co-op is brand new as of after July 1st, then you're required to do it before December 31st, 2026. Now, if you are required to do it by that date, you can do both of these studies simultaneously by the same engineer or architect. Note that you won't be able to use a group in that case because there's different groups that can do each part of this. But if you are required to do it later, you can do them together and you might save some money. But in no event can you do this structural integrity reserve study if you're required to do it after December 31st, 2026. So make sure you get that done. Again, if local requirements exist, so for example, in Broward and Miami-Dade counties, you have to get your recertification after 40 years or 30 years. If you've done that in the past 5 years and it meets the requirements, just like a milestone inspection report that was done recently, you may use that in place of the requirement to have a new structural integrity reserve study. Now, effective in the middle of last year, the statute changed. Within 45 days after receiving it, the association needs to distribute a copy of the actual study to each owner or a notice that a copy is available for inspection upon request. Again, postcard. Save yourself the time and the dollars to mail out that entire report, host it on your website that you're probably required to have or will be required by January of next year, and make sure that it's also sent by U.S. mail or personal delivery or electronically to people that have opted into electronic notices. You also need, in this instance, to provide the division, which is a governmental entity of the state of Florida, with a statement indicating that the study was completed and the association did the mailer that's required. It needs to be provided in the manner established by the division, which is actually just a form posted on the division's website that you can fill out on the website and click through to submit. Now, I understand that there is a portion of that website that asks you to actually attach a copy of the report. This is a practical tip that's not in the slides. You don't have to submit the report itself to the division. You just have to report back that you took care of this requirement. The report itself needs to be maintained for at least 15 years after it's completed. For associations that need to have a website, it also needs to be posted on the website or app, which I only know of one community in Florida that's using an app instead of a website. If you don't do this, again, breach of fiduciary duty. Okay, so make sure you're complying if you need to know, because you're not sure when your building was actually created and when your condo was created, get with your attorney, confirm that date, and confirm the date that you're supposed to have this done, because then you get to rely on advice of counsel and it can no longer be a breach of fiduciary duty unless you should have really, really, really known better than to trust your attorney. And if you're in that position, please, for the love of God, call Kerstin or call me, depending on where you're located. All right, structural integrity reserves, if you're required to maintain them, they need to be maintained for all of the reserve assets pursuant to the declaration. So keep in mind, you're not just looking at the statute to determine what you maintain. You're looking at your declaration. I mentioned the windows earlier. Some communities, that's an association responsibility. That now becomes part of your structure. If it's an unit owner responsibility to maintain those windows and they're exterior to the building, it's still not part of your structural integrity reserve study. Now, the person that's performing the study really should be the one that's interpreting who's responsible for what and what goes in to this study and into the report. But keep in mind, they may ask you. If they ask you, you're not answering, your attorney is. It's not the board's responsibility to interpret the declaration to give them that answer. The amount needs to be based on the findings and recommendings of the most recent structural integrity reserve study. So if you get a study and you don't like the numbers, you have to get another study and pay for it, not just ignore what's in there and say, well, we're not going to follow that. Because the statutes also now require what's called full funding of reserves. We'll get into that in a minute. The association can adjust replacement reserve assessments annually to increase for inflation or any changes in estimates. So if you go out and you get some of the work done, you get an update and you get an estimate for what it'll cost and how long this thing will last, now that the repairs or replacement has been done, you can update that reserve based on that. A lot of people will actually get an update to the structural integrity reserve study for that particular component, rather than rely on what the vendor that did the work told them, because then you don't have any risk whatsoever of not being in compliance with this full funding requirement. My perspective is, if you have information from an engineer or architect telling you how much time this is going to last and what it should cost, that should be sufficient. But to avoid the risk, it might be better from a practical standpoint to just go ahead and get the updated report. All right. If you can't tell how long this thing is going to last, or it's going to last more than 25 years, it doesn't need to be put on the structural integrity reserve study until that time frame gets to be less than 25 years or 25 years exactly, or you can now figure out how long it's going to last. You do need to put away the amount of deferred maintenance expense recommended by the structural integrity reserve study for those particular items. So the amount of money that you're told you need to put away, you still need to put it away. But the report itself and the advice from your engineer or architect or reserve study specialist or reserve specialist is still the amount that needs to be followed. All right, waiving and reducing. So for things that are not structural items according to the statute, this is one that you'll want to ask your attorney if you're not sure. Okay. Waiving non-structural reserves now requires a majority vote of the total voting interests. I mentioned earlier, this used to be a majority of the people that actually showed up at that meeting where a quorum is met. It is a majority of the total voting interests that now need to vote on this. As to the structural integrity reserves, you can't waive them at all for any budget that was adopted after December 31st, 2024, once you've had the reserve study done. So if you've got that reserve study in hand, you have to base the numbers on full funding of those structural integrity reserves, unless an alternative funding method has been approved by the division. Now, keep in mind that requires at least 25 condos in a multi-condo to agree to do this in a different way, that the division actually approves. I haven't seen that done yet in practice, and this has been in the statute since 2022. So bottom line, you're not going to be able to waive, you're not going to be able to reduce any of your structural reserves, the ones that are not considered structural, again, majority vote of the people of the total community. Using them for a different purpose requires the exact same votes. Again, majority of the voting interests for non-structural, structural integrity reserves cannot be used for any other purpose. I think the next slide may say the exception to that now. Let's see. Nope, not in the next slide. Okay. The exception to the you can't use the structural reserves for any other purpose. There was a statute that came into place, I think it was this past year, that essentially states that if your building is condemned and is shut down, you can use the structural integrity reserves and any other funds the association may have for purposes of making it habitable again. And then you need to refund, not refund, but fund those reserves once your building is back to a habitable status. Pooling is going to require a majority of all voting interests. Now, there's nothing in the Florida statutes that says you can use pooling of reserves, and I'll explain what that means in a minute. There's nothing in the Florida statutes that specifically states you can pool your reserves for structural integrity reserves. Okay, so there is some risk there. What I would suggest, again, check with your attorney, get a written opinion that you're allowed to rely on as advice of counsel as to whether this is allowed or not, and then make your decision whether to pool the reserves or not. It is generally something that will mean you put away a lot less money up front for these reserves. Do we get into it? No, we don't, but I think that's in the budgeting section. So we're going to hold off in outlining pooled reserves, but basically straight line is you put away the same amount that is in the line item for each line item, Pooled reserves, you're basically making sure that as each component is expected to fail, you just have enough money to deal with that particular component without necessarily funding all of the other ones until that money is needed. So you might have different amounts in different years, blah, blah, blah. We talked about local government intervention. I guess I stepped ahead one slide. I apologize. So if the building's uninhabitable, you can reduce reserves, you can pause reserves, and technically you can use reserves at the board's determination to make the condo habitable again. Once the building official determines the condo is habitable, you need to immediately resume contributing those reserve funds as part of your budgeting process and your assessment process. Okay, what else? The developer is required to provide this CEUs report upon turnover. That's when the members get to take over control of the board. So I won't go through that in detail. I think it's pretty self-explanatory. Unit owner disclosures to prospective purchasers. I'm going to speed through this because it pertains to unit owners and not the association having to do anything. Let's see. Disputes regarding the milestone inspections and CEUs. Right now, it's considered a breach of fiduciary duty. Effective July 1st, 2027, this is going to be something that is subjected to pre-suit mediation and the filing of a lawsuit. So the division will not be dealing with these issues. And the issues that we're talking about as a dispute: failure to obtain the milestone inspection, failure to obtain the CEUs report, failure to fund reserves as required for structural integrity reserve studies, and failure to make or provide the necessary maintenance or repairs after being told in the milestone inspection report or structural integrity reserve study that there's work that needs to be done to keep the building safe. Okay, no mandatory non-binding arbitration. It needs to go to pre-suit mediation. So we'll get into some covenant enforcement later on. Basically, in a general covenant enforcement context, you've got the option to go to pre-suit mediation, which is what we'd recommend anyway. For various reasons that I'm happy to discuss later, but we're already at 11:50 and I've got a lot of slides to get through. Or you can go to binding or non-binding arbitration with the division. And again, we recommend the mediation aspect because it lets you get straight to court, and also for other various reasons that I won't get into. But here, mandatory mediation is the only option before you file your lawsuit to address the failure to do these things or to properly address milestone inspections and structural integrity reserve studies. Okay, elections, official records, and record keeping is topic 2. And while we get into that, I'm going to take my first sip of water, so excuse me. All right, elections are very straightforward. They've been made a little more complicated by a recent DBPR opinion that I think is frankly largely irrelevant because it's not something that everyone is obligated to follow, even the arbitrator that made the ruling. So the statute and the Florida Administrative Code are very clear as to what the election process looks like for a condo. Most co-ops, in my experience, follow this condo procedure. The Florida Administrative Code says they should. So this is the procedure that we're going to look at. When do we actually need an election? Because it's not every year that you actually need an election. It is every year that you hold an annual meeting, but not necessarily that you need an election. So if there is no vacancy on the board that's caused by the expiration of a director's term, that is what needs to be filled by electing a new member. If the vacancy arises before the expiration of a term, except by a recall, which would require potentially a recall election, which we'll talk about later, that is going to be filled by a vote of majority of the remaining directors, even if there's only one remaining director. So the board gets to decide who fills a spot if that spot opens up on the board during the year. If it opens up because someone's term expired, that's when you'll need an election. Okay. The alternative, I mentioned that the board gets to just appoint someone by board resolution or a vote at an open board meeting. The alternative is to hold an election, but the process that we're about to go through can be so time consuming and costly that I have no idea why you would even potentially want to spend that time and money and make the members show up for this type of meeting, or at least vote at this type of meeting, whether electronically or in person or by mail. I just don't see any reason that you'd want to put yourself through that if you don't have to. My perspective is make it easy, move on with your life, and that's it. All right. So in other words, if you have a vacancy on the board before the expiration of a term, My recommendation is to have the directors meet, have them appoint one or however many open spots exist, and move on with your life. So the election timeline, there are 4 important dates for a condo election and most co-op elections. And I think it might be all co-ops, but I don't want to quote and then be found to be wrong. So I'm going to say, I think. Okay, so the important timeline, not less than 60 days before the actual election meeting, you need to send out what we call the first notice. It's basically a normal meeting notice that just says the time, date, and location that you're going to hold this annual meeting and election. Okay, anyone that is entitled to vote gets that first notice. We'll talk about voting suspensions later. And that's really the only reason you wouldn't be allowed to vote is if your right has been suspended, or if you've got requirements for, let's say, a corporate owner of your condo unit that has not submitted any designation of who has the right to vote. But we'll get into that stuff later. All right, again, we've got that 60-day first notice. Anyone that wants to be a candidate, meaning they want to potentially serve on the board and want to be considered as a potential director, needs to submit a notice of their intent to do so, their intent to be a candidate, no later than 40 days before the scheduled election. If you do not submit that notice of intent to be a candidate, even if you're an existing director whose spot just happened to open up, you cannot serve on that board unless no one puts their name in the hat and you get appointed by the remaining directors. Okay, so understand this is a crucial 40-day timeline. Now you then have 5 more days. By 35 days before the election, anyone that is a candidate can submit a candidate information sheet. That's basically an 8.5 by 11 piece of paper that is going to state the reasons that you think you'd be a good candidate as a director nominee. Now, we have problems with this where it's basically just someone uses this as a means to demean the rest of the board, to argue with what management is doing, to badmouth everyone, or to just say their piece. Unfortunately, the board has no right to change or choose not to send that out unless it is truly troubling, in which case you should really be running that by your attorney and making sure whether you should send it out or if not sending it out is going to create too much risk versus sending it being the risk in and of itself. So again, that sheet needs to be submitted no less than 30 days before the election is supposed to take place. Not less than 14 days or more than 34 days before that annual meeting, and the 34 is so that you give everyone the opportunity to get those information sheets in. You are going to send a second notice of the election. Again, very similar. It's going to say the time, date, and location of the meeting that's going to be held. It's going to probably include your agenda for that meeting, anything that's going to be voted on that's beyond the election itself. And it's going to also include all of these candidate information sheets and an inner and outer envelope and ballot for everyone to use. We'll go through what those ballots and envelopes are used for in a minute. But that's the timeline that you need to follow for every single condo election in Florida. Now, I said there's some risk. You might want to talk to your attorney if your bylaws say that you're supposed to do this differently. The first thing that you're going to want to talk about is, do the bylaws say something different? The second thing is, if they say something different, you're going to want to amend your bylaws to the extent that's feasible based on the member vote that might be required to change it so that you're just following what the Florida statutes and the administrative code require. Because in reality, this is a procedure. And regardless of what's in your governing documents, chances are this procedure that we're outlining now is going to be what you need to follow. Okay, unless otherwise provided in the governing documents, the board is going to be 5 members. Now, if you've got 5 or fewer units, I think I only know of 5 or 6 of those, the board's going to consist of at least 3 members. So if you've got a tiny condo, you don't need to have every single member on the board. You can, but you don't have to. These are minimums, not mandatory numbers. Okay, the term is 1 year unless your bylaws or articles say that you've got staggered terms. Staggered terms are basically where you've got someone serving for 3 years, someone serving for 2 years, someone serving for 1 year, so that you've always got someone on the board that previously served. And presumably because they've already served and hopefully took a class like this one, they actually already know what they're doing. They know where, all of the records are maintained and how to communicate with the manager if you've got one, which frankly, my perspective is every condo should have a manager because then you're getting rid of a lot of the responsibility that caused people to choose not to serve on a board and giving that up to the manager that you're paying instead. All right, so the term is 1 year unless the condo is a timeshare or non-residential, in which case the term is whatever the governing documents say. And then we talked about staggered terms, or if all directors' terms would otherwise expire, but there are no candidates, you just roll over. Meaning you keep everyone that was on the board again next year if you can't have that election because there are no candidates. Term limits. You can't serve more than 8 consecutive years unless 2/3 of all of the votes cast in the election actually approve that, or there aren't enough eligible candidates to have a full board. Now, keep in mind, only board service that starts on or after or occurred on or after July 1st, 2018 can be used. So until July 1st of next year, 2026, no one is subject to this restriction yet. So you don't need for an election held this year or in the first half of next year, you don't need to worry about that, okay? When you will start to worry about it is July 1st, 2026. Now, the loophole that I've heard some people are trying to get closed, but it exists right now. If you are coming up after July 1st, 2026 on that 8 consecutive year term limit, some people say if you drop off of the board and then are reappointed a couple days later, technically you have not served consecutively. There's an alternative argument there that, well, you've served in consecutive years, so that doesn't count. That loophole doesn't need to be fixed. So I would run that by your attorney if you're coming up on this. The better way to do it is comply with the law, get the 2/3 of all votes, or, you know, if there's not enough eligible candidates, you don't need to do anything to make sure that this is okay. If not, then you might have a problem, but you won't have to worry about that until the next time you take this class or sometime in 2026. Co-owners can't serve as directors if your condo or co-op has more than 10 units, unless there's no one else that wants to serve or everyone says it's okay. Election by acclamation is basically where the number of vacancies on the board, so it may be 2 or 3 people, 2 or 3 open spots, there's only 2 or 3 people that actually want to serve and submit their notices of intent to be a candidate. Why would you go through the exercise of having that election rather than just having the meeting and having to sit there and count ballots for a condo when you don't have anyone else that could possibly step in? So unless you've got more candidates than vacancies as of the date of the election, or as of the date that the last date that people can submit, which is that 40 days before, you don't need to have an election. So you should know far in advance, unless someone drops off at the last minute, whether or not you're going to need an election. So that's something you should be able to figure out basically on day 39 before the election, whether you actually need one, or it's just that the board and the individuals that have submitted their intents are going to roll into those director slots. There's no quorum requirement. This is something a lot of people, including attorneys, get wrong in a condo. In an HOA, you need a quorum for an election meeting. In a condo, you only need 20% of the eligible voters to cast a ballot. It doesn't matter whether you have a quorum or not. Okay, tabulation, whoever gets the most votes wins. The official records, meaning all of the documents, including the electronic records pertaining to every single election, need to be maintained by the association in the official records, and we'll go into official records later, for 1 year after the date of the election, vote, or meeting. So my perspective is, once the election result is announced, that's when that 1 year timeline starts. Now, if anyone's not happy with the procedure of the election, note not the outcome, which is their problem. Nothing you can do about the outcome. But if there's a problem with the procedure of how the election was held, one of the things I just said was not done properly. You've got 60 days from the date the election results are announced to challenge the validity of that election and ask for a new election or ask for whatever you're going to ask for. Okay, again, 60 days. So any challenge that's brought after that, your attorney should know that the response to that should be to try and get it dismissed for lack of jurisdiction to hear the challenge because it wasn't filed timely. Okay, a candidate for directorship means an eligible person who's timely submitted the written notice of the intent to become a candidate. Anyone that wants to be a candidate must be eligible. Anyone who's delinquent in payment of any assessment as of the deadline to submit the intent. So again, 40 days before the election, not necessarily the date that you can be The date of the election. That might work in an HOA if you're taking nominations from the floor. In a condo, you've got until that day 40. If you're delinquent on that date, you are not eligible to be a candidate, and you will not be one. Whether the board wants you to be or not, it would be illegal. And I don't use that word very often because illegal doesn't really mean anything. It means it's against this statute, and it would be a basis to challenge the election process to allow this person to stay on the candidates list and go onto the ballot if they are delinquent in assessment. Another thing that'll make you ineligible if you've been suspended or removed by the division, meaning you did something wrong for your condo or another condo under the Condominium Act, which this one doesn't make much sense because if you screwed up under the HOA Act or the Co-op Act, my perspective is you shouldn't be eligible to serve on a condo. I know there might be people that get out of screw up an HOA, buy into a condo, and then now they're allowed to screw that up too. That doesn't make sense to me. If you've been convicted of a felony or convicted of any offense in another state that would be a felony if committed in Florida, you're not eligible unless you have had your civil rights restored, meaning the right to vote, right to hold public office, serve on a jury. You've had those rights restored for at least 5 years as of the date you seek election. So that is as of the date of the election meeting, in my opinion. Now, if you've got 4 years and 364 days as of the date of that election, sorry, but you're not eligible to serve. Or if a criminal charge is pending against the officer or director for doing something wrong under the Condo Act, you can't be appointed or elected as an officer or director of any association. This one they got right, and may not have access to the official records of any association, because the risk is that you're going to change those records to support your criminal defense, except pursuant to a court order. Okay, voting by secret ballot. All of these elections are by secret ballot. So I mentioned the envelopes and the ballots. The process of actually holding the election, unless you're doing it partially electronically, those people just click through, their vote's done. If you're doing it by written ballot, you're going to have a piece of paper that says how to vote, not directing your vote for certain candidates, but here are the candidates, here's how you place your vote. It's your ballot. That's going to go inside an inner envelope. That inner envelope is not marked in any way. Okay, the purpose of that is to be anonymous as to the vote. It is a secret ballot. Now, people will ask, well, what if someone writes on it? What if they screw up and they don't use that outer envelope? My perspective is, okay, that person just waived anonymity. We want to be as inclusive as possible and count as many ballots as we can. Okay, then you've got your outer envelope that does identify the person that's voting for the purpose of being able to check off. Did they vote more than once, even though they only own one unit? In which case, you disregard and mark disregard both of their ballots. Did they submit multiple inner envelopes inside that outer envelope, but they don't own multiple units? We're disregarding those as well. Do they actually own a unit in the condo? If not, probably disregarding those. Now, other things to keep in mind with respect to the voting. A proxy, limited or general, can't be used in the election of board members in a residential condo. You've got your ballot. There's no need for a proxy. You can mail in your ballot if you need to. So there's no need to send someone else to vote for you. And also, more importantly, the people that are on that ballot have already been decided 40 days in advance or 39 days in advance of that election meeting. So there's no need to have, just like you would in an HOA, someone show up because there are nominations from the floor. Again, that can't happen in a condo. The ballots cast using the inner and outer envelopes, like I mentioned, we talked about the exterior of the outer envelope. The inner envelope can only contain one ballot. If the inner envelopes contain more than one ballot, regardless of what anyone else did, regardless of how many votes someone gets, those are disregarded. Okay. The voter needs to sign the exterior of the outer envelope to confirm that they're actually voting, and put in their mailing information or the lot information, or in this case, the unit information in a condo or co-op. When the association receives the ballot, it cannot be rescinded or changed. So this is also different from an HOA. A unit owner may not authorize anyone to vote on their behalf. Ballots improperly cast in that manner are invalid. That's why I said earlier, if you get 2 votes, that's fine. But you can't submit a ballot for someone else. No proxies, nothing else. If you try and violate this provision, you can be fined by the association. Not fun, difficult procedure. I don't like it, but I think Kirsten will get into that later. If you need assistance casting the ballot because you have a disability, that you can attain assistance. Now, verifying the outer envelopes, you can have a separate meeting to actually go through your roster, check off who's authorized to vote, and check off, okay, this person voted for this unit. This person voted for this unit. You can do that at a separate meeting. Doesn't need to be that you waste an hour and a half during the election meeting going through that process of making sure that at least the outer envelopes are valid. You can take care of that beforehand, but that meeting needs to be done by an impartial committee, meaning no board members, no officers, no candidates, none of their spouses. It needs to be open to all the members. You need to notice it at least 48 hours in advance on the property by posting on the property. And it gets held the same day as the election. Okay, so you can do 5 hours before the election. Yeah, we're going to go through all this stuff. A lot of times management firms will take care of that. And you'll have an independent group that is kind of guided by management or by counsel so that you're not sitting there. Like I said, I mean, in a larger community, I've seen it up to 2-3 hours just going through each phase of that process of opening the outer envelopes, opening the inner envelopes, counting the ballots. Let's see. So you're checking those. I talked about the disregarding ones. Someone who engages in fraudulent voting activities related to an election, that is a first-degree misdemeanor. Forgery of a ballot envelope or voting certificate so that you can vote for someone else is a third-degree felony. Bottom line, if you lose that election, it's not going to be the worst thing that's ever happened in the world. It's probably better than spending time in prison or having a huge fine that gets levied by a prosecutor's office. Using threats, bribery, or intimidation related to voting or casting a ballot is what is considered fraudulent voting activity. Electronic voting, we mentioned. I'm going to skip through this because in reality, what you should be doing if you're interested in electronic voting, which I think is a fantastic idea for nearly all communities, unless you really just have everyone that is a little bit antiquated and would not be willing to go on their cell phone or their computer or their tablet to actually vote. But anyone else, my opinion is it's really something that you should look into. There are a lot of good platforms out there. There are several that we work with regularly. And frankly, this makes it a lot less time consuming to get these first and second notices out to people. It makes it less costly in most instances if you're working with the right group. Most of the time, what they'll try and do is replace the cost of mailing with the cost of their services. And so it ends up being cheaper overall because management doesn't need to do anything with this. And the time that the electronic voting vendor is using is already part of the contracted price. So it's something I would definitely look into. The one important thing to note is that you can't do it unless you've got a board resolution that's been made at least 14 days before the meeting when you will be voting with electronic voting. So that's step one that you need to make sure is taken care of. A lot of these vendors will prepare that electronic voting resolution for you. I would have counsel look at it. There are some that I've worked with so frequently that I know it's not going to be a problem, so I don't even charge. My response is just, yep, we're good. Don't worry about it. They have a good form. I'm not worried about it. Now, the other thing that you need to do is have the vendor do all the things on this slide here. That's not really going to be something you need to worry about. You're going to use a vendor that's been vetted. Now, the first notice needs to include that you're using online voting. There are other things that you'll need to do with respect to online voting, but we just don't have the time to go through everything right now because I'm on slide 59 and I want to get you some time for Q&A before I disappear at around 1 o'clock. So the officers, you need to understand there is a big distinction in the different hats that the people in your community might wear. So you've got your members. Those are the unit owners. Regardless of whatever role they may play in your community, those are the members. Then you've got the directors. We've talked about that kind of ad nauseum at this point, who the directors are. In reality, those are the people that make most of the decisions for your community. They vote at board meetings, they attend board meetings, they second motions, they make motions, or they abstain from voting. That's what the directors do. It sounds super simple, but they are some of the most important people in your community because they have the control unless the members get to vote for a specific item. The day-to-day, 99% of the time, is going to be decided by that board of directors. So those are the directors. Then you've got your officers, which is what we're talking about here. Unless the bylaws say otherwise, the board needs to have a president, a secretary, and a treasurer who perform the duties of those officers. Now, here it says the board, but it's really the association needs to have these officers. And they have those typical duties. The president is the mouthpiece. They sign the documents, the contracts, and things of that nature. The secretary maintains the records, maintains the meeting minutes, but that's usually going to be done by your manager if you've got one. And the treasurer is going to keep the money, keep the accounts, keep the ledgers of who owes what, pay the bills. But again, most of that is done by your manager if you have one. And your vice president really has zero obligations whatsoever, which is good for that person, other than their duties separately as a director. So the board can appoint other officers. You can have a vice treasurer. I've seen that happen, especially in larger communities where that's a huge undertaking to make sure that everything is taken care of. Unless the bylaws say otherwise, the officers serve without compensation and at the pleasure of the board. What does this mean? You could technically pay your officers if the bylaws say so. I don't think that's a good idea unless you've got professional business people that are running your corporation like a business, and that is the only reason they're being paid. The reason I say that is because we'll get into conflicts of interest later, and your members, if this is not in the bylaws, will and should say that any compensation for the directors and for the officers is a conflict of interest. They're generally selected by the board at your organizational meeting immediately following the election. Now, that's how you select the directors for that year, but there's nothing that says you can't switch officers midstream. So if John gets sick and needs to take a break from being the president of the association because he doesn't think he can meet the requirements to make it to all the board meetings, and he doesn't want to have to show up at meetings with potential vendors to sign contracts, John might step down altogether. But the alternative would be that someone else steps into that president seat. All that requires is a board vote or a unanimous resolution in writing of the board that replaces a board vote. Now, directors can't vote by proxy or secret ballot at board meetings, but the election of directors can be done by secret ballot by the directors. I've never actually seen it that way. 99% of the time it's, hey, Jim, you want to be the president? Yep. All right, great. Hey, Jane, do you want to actually serve as secretary? You were the treasurer last year, did a great job. We'd be happy to have you stay. Yeah, that sounds good. And as to each one of those, the members just vote. So you just make a motion, or I'm sorry, the directors vote as to who's in which officer slot. Disqualification from service. We talked about a couple earlier. But if you accept a kickback, which is basically something of value that you didn't pay for, doesn't matter if it's a service or a physical item, doesn't matter if it was borrowed or given, it's a kickback. That is a third-degree felony subject to civil penalties and will result in removal from office and a vacancy declared that the directors get to fill. An officer or director charged by information or indictment, meaning by the actual prosecutor's office, not by the neighbor that doesn't like them and said, oh, well, they committed a crime. They forged a ballot. They stole association funds. They destroyed association records. That's not good enough to pull someone off the board. It's good enough to create a question and to maybe have police look into it, but it's not good enough to get them off the board until a prosecutor decides there's enough evidence to support that claim. So it needs to be an actual charge. And then a director who's more than 90 days delinquent in any monetary obligation to the association is considered to have abandoned their seat. That means you're off permanently until you pay that in full, at which point the directors might have already filled that seat with someone else for the rest of your term. So this is not a suspension, it's a bye-bye. Now, going back to the information or indictment of a condo crime, so to speak, if the charges are resolved and your term hasn't ended yet, you are put back and reinstated. Okay, if there's a finding of no guilt or the charges are dropped, you go back on the board, even if the association has filled your spot. That's a suspension. Okay, but again, if you have those charges pending at the time that the election takes place, you're not eligible to serve on the board anyway. If you violate the official records inspection requirements 2 or more times within a 12-month period. Now, that's knowing and willful violation. I don't see that really happening if you've got a manager, because the manager is going to be the one that is handling those records inspection requests. But if for some reason it is the directors that are handling those requests, it is a second-degree misdemeanor and you must be removed from office if 2 or more times within a 12-month period you knowingly and willfully fail to produce those records when you're obligated. We'll get into those records inspection requests later. Anyone who knowingly or intentionally defaces or destroys accounting records or fails to create or maintain them in the interest of getting away with a crime is a first-degree misdemeanor in and of itself. If you knowingly refuse to release or otherwise produce association records to escape detection of a crime, that in and of itself is a third-degree felony, regardless of what the crime was and regardless of what the charge would have been. Okay, someone who uses a debit card issued in the name of the association. I think this is insane, but my solution is use a credit card instead, or use your own debit card and be reimbursed for the expense, or use it in your own name and have it not be billed directly to the association. But anything that is not a lawful obligation to the association that is paid with a debit card in the name of the association or billed directly to the association is considered theft. That will require you to be removed from office. A vacancy is declared, and it is also a misdemeanor. We might be at the point, I don't remember where it is actually a felony. I think it's still a misdemeanor as of now. We'll get to that, I'm sure. Okay, if the board finds that the officers violated the conflict of interest requirements that we'll get into later, that is also a reason to remove someone from office. And if you fail to timely file the written certification that you've taken this class within 90 days after being elected or appointed to the board, you are also off the board. Condo websites, I told you we'd get into them. Here we are. If you have 150 or more units that the association maintains, you need to create a website. That was effective January 1st, 2019. If you are in that size condo and still don't have a website, oh my God, what have you been doing? If you are 25 or more units, pay attention, because if you have 25 or more units and you didn't have to have a website before, you're going to have one effective January 1st, 2026. Now, the good news is 99% of what needs to go on that website is already being covered by almost every management firm I know of. I know Artemis is one of them that's taking care of this. Okay, they're taking care of this entire requirement for you. The only thing you might need to have is a front page that they provide for you that basically provides certain information, including the manager's information, their office hours, so to speak, as well as notices and agendas for meeting minutes or for meetings that are coming up. But the association website does have specific requirements. Basically, it needs to be password protected so that not everyone has access to all of the information on there. It needs to be operated by a third party, which could include your manager for that matter. And it needs to include certain official records of the association. It needs to be accessible through the internet. I hope that was obvious since it's a website, but some people are not really paying attention, I guess. Or other protected location that's inaccessible to the general public. Again, you need a username and password for each member that's going to access this. It needs to include a current copy of certain documents. We've got the full list here, and frankly, this is a great way to not waste your time by not going through them line by line. But there are differences, keep in mind, between what needs to be on your website versus what needs to be in your official records. So your official records is any document that pertains to the operation of the association, or anything in writing that pertains to the operation or maintenance of the association. This is different. So there are also requirements. If you have a meeting notice coming, if a meeting coming up, if it's a board meeting, you need to post that on the website, not only in the community, but on the website 48 hours in advance of that meeting. You also need to put any documents that'll be considered during that board meeting on the website, at least, no less than, excuse me, I'm going to take a sip.
You do
No
that.
less than,
And while Alan's taking a sip, I'm going to mention These slides are going to be available after you fill out the evaluation at the end. You'll click a link and you'll get them. So whatever is not gone through in detail, you will have this. Back to you, sir.
Thank you. And that breather was appreciated, Jeff. So again, board meeting 48 hours in advance. You need to post everything, including any contracts you're considering signing during that meeting. If it's a member meeting, it's a 14-day notice requirement, just like you had before, but now it also needs to be posted to the website, the notice and the agenda at least 14 days before. Any documents you're considering voting on during that meeting, might be amendments, might be something else, need to be on that website at least 7 days before that meeting. So again, you've got certain requirements. That's one of the more important ones that people might miss if I didn't mention it specifically. Failure to post these documents doesn't invalidate any action or decision by the association. That's something I've been hearing frequently since this website requirement came in. You do need to post it, but if you don't, that doesn't mean that you weren't allowed to vote on it. It means you made frankly, probably a harmless error. Because the reality is, especially at a board meeting, if the members don't get to see it in advance, they weren't going to vote on it anyway. They were allowed to make comments on it. At a member meeting, anyone who sees something in advance that's going to vote on it should probably just vote no if they're not sure if they want to vote yes. That's it. There's no liability for disclosing or posting information, but you do need to restrict what you're posting. One of the more important things not to post is the same personal information, that's restricted, where if someone was going to send a records inspection request, you wouldn't be producing that information. All of that is exempted from being posted on the website. You can use a mobile app instead of a website. Now we get into official records. So we talked about some of this. Again, I'm not going to go through line item by line item because we have number 19 here, all written records, even if not specifically included in the statute, that relate to the operation of the association. What does that mean? Literally anything that's in writing that pertains to the operation of the association needs to go into your official records. Most of it is accessible to the members for inspection and copying. So just keep in mind, you send a letter, that is an official record, or it must be made an official record, and it needs to go to your manager or your secretary, whoever is maintaining those official records. Now, the records generally need to be maintained for 7 years. Okay, that means that you're keeping them for at least 7 years, except certain records now need to be permanently kept. Now, what you're supposed to do if you got rid of those before the statute was changed to say you need to keep them permanently, I think it was 2 years ago. I don't know what you're supposed to do, but hopefully no one has gotten rid of these important documents. Your recorded governing documents, your plans, permits, warranties, and other items provided by the developer, your current rules, and all meeting minutes. Now, the all meeting minutes is the one where you might have gotten rid of some of this in the past. So understand that now you are going to have to keep all meeting minutes in your official records. We mentioned the CEUs and inspection reports. You need to keep them for 15 years. We mentioned the election records for 1 year. The other one that you're keeping for 1 year is bids for work to be performed for materials, equipment, or services. That is a 1-year maintenance requirement. Now, you also need to have a records retention policy that says how you're going to maintain these records, where you're going to maintain them, what you're going to do on your website, when you're going to destroy the records, and how you're going to destroy them, and whether or not, hint, hint, not, you're going to give the members notice before these records are destroyed. Okay, so they need to be maintained in an organized manner. This is another change that came about last year. Generally speaking, it was, here's our box of crap, best of luck to you in finding what you need. Have a nice day. We'll be maintaining and making sure that you don't delete anything or take anything out of these records. You actually have to maintain your records now in an organized manner that, and the word is facilitates, makes it easier for the owners to actually perform their inspection and find what they're looking for. If records are lost, this is another change from this past year. If records are lost, destroyed, or otherwise unavailable, the obligation to maintain them goes to a good faith obligation to obtain and recover lost records if reasonably possible. So you actually have to make an effort to recover the records that you somehow lost at some point. You never had that obligation until July 1st of last year. Inspection and copying of records. This is one that people screw up too. So hopefully in listening to me, you won't. And again, your manager is probably going to be the one that really takes care of this if you've got a community manager. But if you receive a written request by the board or its designee, the official records of the association must be made available to the owner and the owner's authorized representative within 10 business days, within 45 miles of the condo, or in the same county where the condo is located. So you cannot have your South Florida community have the records inspection offered in Kissimmee office of a management firm. That won't work. Okay, it's got to be within 45 miles or within the county. Now, I mentioned 10 business days. That doesn't mean you have 10 calendar days. It means Monday through Friday without counting holidays. If the last day falls on Saturday, you're pushing that forward to Monday. Now, I also mentioned two things that are important to note. Written request. Someone calls you and said, hey, I want to look at these records. Your response is put it in writing or just, nah. That's an accurate response. Now, I wouldn't say no. I would say we need to get that in writing. And another policy that I'd recommend every condominium in Florida have, and every co-op in Florida have, is a records inspection policy governing when you can ask for this, how frequently, how long the owners can sit and inspect these records, what it's going to cost them to make copies or pull items from the archives, etc. So that's policy number 2 that I think everyone should have. There's a list of 7 or 8. If you need that list, shoot me an email and I'll be happy to provide it at no charge. I won't prepare them at no charge, but I'll provide it at no charge. So the other one that's important is and the owner's authorized representative. It was an or up until last year. So we could say, well, no, you can't have 2 people walking into this room. You can send your attorney or you can send the owner. You can send John's cousin or you can send John. Now it is and the representative, so they can inspect those records together at this point. Don't say no just because it's 2 people coming in. Now there needs to be some kind of authorization, but that can literally be a verbal, well, we're both here and I think that my cousin will do a better job at looking at these records than I can. That's good enough. Okay. Renters generally don't have the right to inspect and copy the records, but they do have all of the declaration, bylaws, rules, and inspection reports. They can inspect those records. The association, this is a good one. You can have a copy of the official records available for inspection or copying on the property. That one is the way that it's always been. Or you can offer to make them available electronically via the internet. If they're posted on the website, which is what I would suggest that every condo consider doing now that this kicked in last year that you're allowed to do it this way, you can complete every records inspection by saying, it's all on the website. Have a nice day. Let us know if you're incapable of accessing the website or if you don't have login credentials and we'll provide them. Now, you might need to provide a computer screen and allow them to view it there if it's on the website and log in and, print it upon request at their expense. Up to 25 pages is free. Anything more than that, you can charge up to 25 cents a page. Let's see. The right to inspect includes the right to make copies, as I mentioned. Association can allow a member or the authorized representative, but it's really and to use a portable device free of charge to make their own copies. If they bring a scanner with them, they can scan the records. If they bring a printer with them, they can print the records there, not using your paper or toner, but they can make copies however they want. The associate, and when I say however they want, I don't mean that they can make as many copies as they want on your copy machine. The association does need to maintain whatever the hell an adequate number of copies of the declaration, articles, bylaws, and amendments is. The rules, the Q&A sheet, year-end financials, etc. No one knows what an adequate number is. It might be 1, it might be 25, depending on how frequently people actually ask to inspect and copy those documents. Just because you have those available doesn't mean you have to hand them over. You can charge the cost of making that copy to the member before you make the next copy for the next person that asks for it, if they want to take it with them. If they just want to inspect it, that's fine. You don't charge them anything for the inspection itself. It's just the copying and if the records need to be pulled from storage. Again, another law that took effect July 1st of last year, if you are providing this inspection, which you should if you get the request, you need to keep a checklist of all the records that were made available and all the records that you didn't make available. That checklist needs to be maintained for 7 years, and the association delivering a checklist pursuant to the requirement creates a rebuttable presumption that the association did what it was required to do with respect to the inspection. Now, that checklist, I freaked out when I first read this. And I said, we have to know every single document that this community has. Well, DBPR hasn't really been clear how they're going to rule on this issue. And our perspective at this point is that if you have a list of the categories of items that you did or didn't provide, which your attorney can prepare for you, then you can provide that. And it's just the same form every single time you do a records inspection request. So that might be an easier way of getting by than trying to sit there and maintain a list of every single piece of official records you have. If you're going to do that entire list, I strongly recommend that you make sure you've got that records retention policy in place and you actually destroy the records when you're allowed to, because otherwise that list could be 20 pages long in and of itself. Like I said, you can have rules governing the frequency, time, location, notice, and manner of records inspections. You can say it's got to be submitted via certified mail, not just, hey, I'm emailing John the president and telling him I want to look at these documents. It doesn't have to be in a specific format. It can just be, I want to review the contract with John between the association and John Smith Plumbing, whatever it may be. There doesn't need to be a specific format. Okay. You also cannot require an owner to show a proper purpose or a reason for the inspection. As an owner, they have the right to inspect the records, period. Now, I mentioned that there are certain records that are exempt from production and inspection. This is the list right here. So you want any of your communications with counsel are generally going to be not subject to disclosure as part of a records inspection. And any of the things that we mentioned on this list, by the way, are also things that you won't put on the website, at least not in the general population area. I don't like to call a website area Gen Pop, but comparing it to a prison situation where everyone in the community has access. What I would do if you're going to put those records online so that they are accessible, make it so that the board and the people that actually need that information, so for example, maybe your attorney, your manager, all of them have access, but not the general association membership. All right. So again, the first one is attorney-client privilege, attorney work product. You're not required to breach that attorney-client privilege by giving away this information to the members. Information obtained in connection with approval of the lease, sale, or other transfer of a unit. So your background checks, the application for those background checks, things of that nature, bank records of an individual member, things like that, or of a tenant, prospective tenant. Those are not subject to disclosure. Personnel records of the association or the management company employee. Now, that doesn't mean you're not telling people what the written employment agreement actually says. It just means that the, hey, this person was written up. That's not necessarily something that you're giving them. It also doesn't mean that you can't give away, and frankly, you should give out the information regarding the budget or the financial records that indicate what this person was paid. Okay. Another one, medical records of unit owners. Usually you're going to get this in connection with a personal injury case or a disability related request for an accommodation. Kerstin will get into that one later. But those are not subject to disclosure. Electronic security measures used by the association to safeguard data, including passwords. I hope it's obvious why you wouldn't be giving that information to literally everyone in the community. Software and operating systems used by the association that allow manipulation of data, even if the owner owns a copy. What you're going to do here is produce a report, a printout, not the raw data itself or access to the software. All affirmative acknowledgments made under 718-121, which is the method of delivering your notices for when you're changing the method of invoicing the owners for assessments, things of that nature. And then we have true private information that is not going to go out. And again, I'm not going to go through these items in detail, but the association can print and distribute a directory containing the name, unit address, and telephone numbers, and any email address or mailing address that is used for purposes of notice. That's basically your roster. However, an owner can exclude their telephone number from the directory by written request to the association. Association is not liable for inadvertently disclosing any of this information. You can consent to disclosing any of it. Again, same thing with the website. You're not going to put this information on the website, or if you do, it's going to be behind specialized login credentials that do not apply to the general membership. There's a no harm, no foul, where if you, unless you knowingly or intentionally disregarded the protections that the members are afforded in giving away their personal information, the association or the individual directors or the manager shouldn't be held responsible if that information is used for bad purposes or if it was given inadvertently, meaning you had the obligation to redact that social security number. You didn't even look at it. You just, it was a brain fart that you really should have, and yes, that's a legal term, by the way, you really should have looked at it a lot more closely to make sure you're not giving away confidential information, but you kind of gave away the box and said, do what you got to do. Okay. That's not wrong, but it's knowing or intentional disregard. The question is whether that's an intentional disregard if you didn't even think about it. Okay. Misuse of information, again, not the association's responsibility. Attorney-client privilege, I mentioned a minute ago. Okay. This is where any documents between the attorney and its client, meaning the association. And I do want to be clear here who we represent when we have a client. It's the corporate entity itself that you guys as directors are running. We don't represent any management firms. We very, very rarely represent individuals. We don't represent the board or individual directors or officers unless we're required to do so, or we choose to do so because they're being sued individually and we're representing the association and we represent them through an indemnity clause. They're not our direct client. The association itself, the corporate entity, is our client. So communications between our firm or your attorney and that client, the association, through the board, the manager, or our law firm, are protected by attorney-client privilege. The only person or entity that has the right to waive that privilege, meaning allow someone outside of that group of three types of individuals, the management firm, the attorney, and the board, the only person or entity that can decide to waive that is the board. Okay, even if a judge asks me for confidential information that's attorney-client privileged, I'm not allowed to disclose it. My firm's not allowed to disclose it. It is privileged, and I don't get that privilege. The privilege is to the association, and the members don't get to decide that. No individual director gets to decide that either. So when you have communications with your attorney, those communications don't get dispersed to the members. I don't care about your desire to be transparent. I'm just going to be blunt. Okay, you can be transparent and say we had a discussion with our attorney. We're getting guidance to make sure we handle this correctly. You're not going to say what was discussed that is privileged. And I might be a little adamant right now, but I've had several clients in the last few months that didn't seem to understand this no matter how many times I explained it, and they got the community in trouble because the entire strategy that we were planning on using for a lawsuit was disclosed to the other side before we even filed. That's dangerous. Don't do it.
Alan, maybe they had that new legal term we learned about today. They had a brain fart.
I think it was intentional in these particular instances because the person said they were going to do it, but that is a good thought. Okay, failure to timely provide access, meaning you don't comply with that 10 business day requirement after you receive the written request. That creates what's called a rebuttable presumption that the association was intentional in failing to comply with that timeline. What does that mean? The owner gets a $500 gift, depending on how long it takes you to produce those records afterwards. I say it's a $500 gift because it's damages that are statutory and automatic if you're not able to prove that it wasn't intentional once that rebuttable presumption arises. A presumption is the court is going to presume that, well, you know what, they did this intentionally because it was more than 10 business days. Unless they can prove, which is the rebuttable part, unless the association can prove that this was not intentional, I'm going to presume it was. Now, if that presumption is found to be correct or isn't disputed or isn't defeated, that is a $50 per day damages that the owner's entitled to starting on business day 11 up through business day 20. Okay. So it's up to 10 days. And that is a $50 per day plus attorney's fees and costs if the owner has to actually pursue getting a court order to receive the records. So let's see. We talked about the willing and knowing failure to provide these records. And if you fail to do it in furtherance of a crime, it's tampering with physical evidence or obstruction of justice, which is in and of itself a separate crime. If you deface or destroy these records, I think we actually talked about all of this already. So we're going to move forward. An outgoing board member. This doesn't exist in an HOA, but it's very important, and I wish it did. If you are leaving the board, you are pulled off the board, or your term expires, then within 5 days after the election or 5 days after you are off the board, you do need to produce all records and all property of the association back to the association. Now, some people will say, well, I thought you had a copy of that. Well, I don't care. It all goes back to the association. You want to keep your own copies? That's totally fine with me. But you need to give it all back to the association, especially access to bank accounts, things of that nature, which I've never seen it happen with Artemis, but other management firms where they don't have access to the bank account for a month and a half after they turned over to a new management company. That's dangerous. Okay, if you fail to do this, you're subject to civil penalties by the division. And now I am done for now. I'm going to go on. Jeff, if you want to do the usual Q&A, or if you've got anything that you want to add right now, we can certainly do that.
But I am marking down April 25th on my calendar because it took over 3.5 years. Took over 3.5 years, but I got you to laugh. It wasn't much of a laugh, but I got you to laugh in the middle of your session, and that is a first, ladies and gentlemen. That is a
I'm
first.
impressed. You managed.
That is a first. So before Alan gets to the Q&A, I just want to mention, remember to, this is the time where you can go, we're not taking an official break. So now's a good time to go do a bio break, get a drink, come on, leave it running, come on back as quick as you can. A few people did chat to me on the side asking what happens if I lose my internet connection? Am I going to get penalized? Zoom shows the timestamps in and out. So if you get booted off and you come back in, I will be able to see that on the spreadsheet afterwards. If I see a 30-minute gap, okay. If I see a few minutes, don't worry about it. You'll be fine. Just as long as we see you're making the effort to come back in. And then I see somebody put something in the Q&A about something I might have said earlier. This is for condos. Remember, if you are governed by 718, you're in a condominium association. This is the class for certification. And also, last thing I say before Alan does Q&A, not to be confused with board member continuing education. Two different things. This is the certification. I have a feeling as we get towards the new legislation passing at the end of this, early in the summertime, we'll have some direction about where we go for both condo and HOA continuing education. We, nor any other provider, has been given any direction on that as of yet. I have a feeling they're waiting for some of the new laws to pass. All right, so Alan, back to you guys.
Yeah, and as a preliminary thought, I agree. I think it's a little ridiculous that the legislature decided in July of last year that this continuing education is required. And literally almost a year later, DBPR has not actually authorized anyone to teach those classes.
Yeah, I shouldn't have said anything yet. They should have kept it quiet for a while.
Well, I mean, it should be within X amount of time after it's actually authorized. But bottom line, you're going to get into, I think Kerstin's probably going to talk about these classes that we're mentioning. I'll let her make the commentary so that I'm not taking up too much time because I got 13 minutes until we're at the halfway mark. And I don't want to take up any of Kerstin's speaking time, even though I let her take some of mine. That's okay. All right. So I saw that Jeff sent is a kickback only something given for free.
Yeah,
Generally,
what if a vendor says, entices a board member, I'm going to give you a new roof at 95% off the retail rate. Is that a
it's
kickback?
any discount, anything you get of value without paying for that value. So
But
a major
you're getting a
discount would be,
95% discount.
yeah, frankly, even a 5% discount that the vendor wouldn't give to everyone
Got
is
it.
a kickback.
I hope that clarifies it because I know that's
Yeah.
going to come up.
Yeah, it's something that you get of value that you don't pay for. That's what a kickback is. So good question, good clarification. Julio asks, is the milestone synonymous with a 25, 30, or 40-year recertification? Synonymous, yes. Exactly the same, probably not. So, and when we're talking about milestones, it's also the structural integrity reserve study that is somewhat synonymous. Okay, Beatrice asks, when do you start counting the time for the next 10 years? I presume this pertains either to milestone inspections or to structural integrity reserve studies. Either way, you start counting the 10 years from the date that the previous one was completed. So that's a pretty straightforward answer for both of those, regardless of which one you're asking. Jenny asks, I have an inspection company. My condo paid in full, and 4 months later, we still don't get the report. It's only 42 units. What can I do as a manager? You can reach out to the attorney to see if you can find that vendor in breach of that contract and maybe either get out of the contract or force them to actually move forward with a demand from the attorney saying, we are not paying you for anything. And if we paid you, and I see that you say we paid in full, demand the money back if they're not going to do their job. Page 25, I don't remember what was on page 25.
Clarified in the next comment there, the 10-year
Oh,
rule.
good. Every 10 years, how long has that been in place? That's been since 2022. Will full CERS be mandatory in 2026? Well, that depends on what the legislature does, Victoria. The likelihood is probably yes. But there are potential shifts going on right now that might say you don't need full funding, which is what's required now. There are also shifts saying that some communities that need it now, there might be additional exceptions. The one that I heard about is you only need a structural integrity reserve study if you're 6 stories or higher, but none of that has kicked in right now. So the thing to worry about right now is what the law currently says. You know, I can speculate as to what the changes are going to be. I can speak with legislators day in, day out, which our firm does. But whether they listen and whether the vote overall goes in the direction that we think it should, we don't really have a ton of control over that. So we can only provide our opinion on what works and what doesn't in Florida. The legislators get to decide how they individually vote. Jenny, do we have to provide the master insurance to individual owners? I'm not sure what you're referring to. If you're talking about the insurance policy that's maintained by the Condominium Association, the answer is yes, that needs to be in your official records and it's not exempt from production.
Put it on the website.
Yep, put it on the website, put it in your official records. Gail asks, are owners entitled to have the list of renters in the community and their information? Nope, they are entitled to the unit owner's information, not tenants' information. Maybe as to the number of units that are rented, or as to the individual units that are rented, because that'll be reflected in other records that they probably are entitled to, but not as to the actual applications, the renter's contact information, or anything like that. William asks, and if that's you, Dutch, good to see you. Candidate being delinquent the day before the election date or on election day, consequences. If they are delinquent before the election date, it depends whether they were delinquent when they were trying to be a candidate. If they were delinquent on the 40th day before or at any time between then and the election, they're probably not eligible. So just keep that in mind. If Virginia asks, if a person in the heat of the moment declines a board position verbally at the election, is that legal? Yeah, you can say you don't want to serve on the board whenever you want. If so, how's the vacancy filled? As I mentioned earlier, that would be one of those vacancies that won't be filled by the election. So it gets either filled by appointment by the rest of the directors, or it gets filled by another election scheduled for a later date for that one open slot. Charles asks, did I misunderstand, but was there a comment about a 14-day notice for a meeting? That would be a member meeting. Now, I didn't mention it because Kerstin's going to get to it later, but there are 2 other things that will require a 14-day notice for a board meeting. That is if you're voting on a special assessment. or if you are voting on changes to restrictions governing use of the units. But generally speaking, we're talking board meeting, 48 hours notice, member meeting, 14 days notice. Now, that's another one of the things that the legislature is in the process of hopefully not screwing up, because there is a current draft of a bill that says you need 14 days notice for every meeting, and that would be a complete debacle. There is a concerted effort to remove that provision from the proposed.
Everything that comes out of there makes sense all the time. You know that.
Yeah, always.
Always.
Donald asked, you may see I signed in twice. Okay, it sounds like that's going to be a technical difficulty
Yeah, don't worry.
question, so I'll
You can
skip it.
that one.
Joe,
take
what happens if your association requires a credit score and a background check, but it's not in the documents? It needs to, at least in my opinion, be in the rules and regulations, and the association needs to have the ability to actually screen. We have a completely separate class on purchases and buyers and screening tenants. I would suggest you check out a past recording of that class, Joe, because that'll answer your question in a lot more detail than I have time for in 7 minutes.
I could send that to you, Joe.
Yeah, that'll work. Ed asked, does an association have an obligation to keep certificates of voting authority when there are more than 2 owners? Yes, those are official records. Beatrice asks, is the Bill 13 changing the CEUs? There are bills that are proposing to change structural integrity reserve study requirements. Whether any or all of them will pass, I can't even guess as of right now. Amir, our 2-story condo townhouses and insurance forces us to go through milestone. Can we fight this? Yes, by getting a different insurance company, unfortunately. There are a lot of insurance companies that are recently requiring things that, frankly, are absolutely not required under Florida law. But if they're going to insure your building, they want to make sure that you're actually structurally sound. And so there are insurance companies that are requiring these things of condos that really don't need them. I saw that we skipped, what does CERS mean? Structural Integrity Reserve Study is a
I just
CERS.
typed the answer there so everybody
Thank
can
you.
see it.
But just so everyone has it. Anthony asks, once again, what's the term limit for being an officer such as president? There's no term limit for presidency. There is a term limit for serving as a director. So it has nothing to do with presidents. It is 8 years, and it started when the statute came into place on July 1st, 2018. So you've got until 2026 in July before that actually kicks in practice. Helene asks, how do I find out how old my building is? Go to the county records office, probably the building department of your county, and you can ask them to look into it for you and give you the answer. Nemrod asks, what can the board do to get back a special assessment to fix CERS? Well, what the board can do is levy a special assessment. You just need to follow the procedures that are set out in your governing documents. Now, there is one of the changes that is being proposed presently is that you would be allowed, regardless of what's in the governing documents, to fund the CERS via special assessments. That one doesn't look like it's going to pass. The other one is to fund it via either a loan or a line of credit. So you might need a special assessment to fund the payment towards that loan, but it's not actually directly funding the structural integrity reserve studies. Victoria asks, if a Florida condo director, they're not paid professionals, and a former president breached fiduciary duty by approving expenses without board approval, is there anything that can be done? Yes, you can talk to your lawyer. That's not what I'm touching with a 10-foot pole unless you are a current client of the firm. A candidate being delinquent the day before the election. Yeah, we went through this one. Steve asks, if the condo doesn't have any ownership in the structure owned by a hotel, how do we comply with structural integrity? If you have no ownership, you're only going to have the structural integrity reserve study done from your perspective as a condo association for the components of the building. If you don't own any portion of the structure, you might not need a structural integrity reserve study at all. So that's one I would ask your attorney about. Yeah, I'm not sure, even in connection with the previous question, what Nemrod's asking. I apologize. If you want to email me separately, I'll be happy to help if I can. Victoria, my management office said they tell directors the rules, but aren't responsible for enforcing them. So basically the directors do what they want. No, the directors do what they want and then they get sued for breach of fiduciary duty, or the directors do what they want and then the members of the community will point out that they're doing it wrong and threaten a lawsuit or possibly file one against the association itself. The alternative is if the directors don't know what they're doing and refuse to learn what they're doing, perhaps by taking a class like this or getting advice of counsel, then there is a recall, which Kerstin will talk about later, that could be an option for you. Not always the best one, but it is one. Steve asked, if an owner has a delinquency fine, can that owner run for the board? They can potentially run, but probably not, because it's as of the date that you put your name in the hat that if you're delinquent, you can no longer run because you're not an eligible candidate. Sheila, if I want to stop serving on the board, how do I proceed? Well, sorry. So do most people that are on the board, but that's kind of how the cookie crumbles sometimes. Basically, what you're going to do is send your resignation in writing to the rest of the board, and if you have a manager, to that person. And you might want to discuss what might be done better before resigning, but that's your prerogative.
Yeah, it's not an easy gig.
Go ahead. I'm sorry.
I'm saying it's not an easy gig. You got to try.
No, it's not. And it's often thankless and it's mostly unpaid.
Yeah.
And I get that, but you know, risking that someone that knows less than you and cares less than you is going to end up in your spot. Whether you want to take that risk, totally up to you.
Alan, do one more, because then I'm
Okay.
going to do a 30-second housekeeping.
All right, I'm going to skip Anthony's question because that's a Kerstin one. If a unit owner says they can't pay an assessment, what options exist for the association? That's more of a Kerstin, but I'll answer it anyway because people tell me I'm the collection guru, and I like to take that praise because I don't have an ego, but that boosts the non-existent ego. If they can't pay an assessment, you can collect anyway and say, well, you have the obligation to pay. So if you can't pay, we'll go ahead and collect the assessment and foreclose eventually. The alternative is if they can't pay the assessment, but they can pay going forward. Let's say it's been, 6 months and they haven't paid anything and you're trying to help them catch up. 1, take a loan. 2, sell your unit if you can't afford the assessments. If you can't afford to live here, don't live here. Or 3, the kinder, gentler approach, reach a settlement with them where they agree to pay the assessment over time and pay all future assessments within, the deadline when it would have come due, but make sure that that agreement is prepared or reviewed by counsel. It's put in writing. It's not just verbal or a couple emails saying, yeah, we'll accept it this way, and that it contains concrete consequences for the owner failing to comply. I so frequently see people that have these verbal agreements. Yeah, you can pay it whenever you have the money, or you can pay it over the next 6 months, but then there's 6 months in arrears because you didn't bother to put in there that they have to pay the current as it comes due, or there's no consequence. So they default 3 months in, and now all of a sudden it's, well, I guess we send a notice of late assessment. So what I would want to see in that type of agreement is that they're waiving all pre-suit notices, admitting that they owe the money so that you don't have to fight about that in court later on. And whatever else your attorney tells you to throw in there. There are other things that our firm adds into that type of agreement. And we do have, I can prepare a form for current clients. I don't necessarily do that on the side. But if you want to work with our firm or you're already working with our firm, speak with your attorney and we can take care of that for you. If not, and you're happy with your attorney, speak with them and let them take care of it. All right. Well, thank you all again. I really appreciate it. It's going to be great not having a voice by the time I get home this afternoon, thanks to 2 hours of nonstop speaking. Thank you again to Artemis for having the firm on with you. And Kerstin, thank you for taking on the second half. And Jeff, always great to work with you, brother.
You too, sir. You too. Have a good time with the family.
All right. And again, if anyone needs to reach me or actually wants to reach me, my email address is probably the easiest way. I do post on LinkedIn like a crazy lawyer, pretty much 2 to 3 to 4 days a week, depending on how much free time I have to think of something that I actually want to say. All right. So feel free to follow me there. But if you need me, email is always going to be best, as@kbrlegal.com. Thanks again, everybody.
Remember, April 25th. I'm going to remind you every year. It's the day I made you crack. All right. Have a great day, Alan.
Thank
you. Talk to you later. And before Kerstin comes on and before Diane says a few words before we continue, just a reminder, if you haven't already done so, please hit the chat button simply so the chat interface appears. Don't worry if it says chat is disabled. There is nothing for you to enable. Just hit the chat button so it shows up, and we will be sending the evaluation link your way later on towards the end of the webinar. So with that said, I want to now turn it back over to Diane. Do you have anything you want to mention before we get started with the second half?
No, I think I'm good. I hope everyone's still, lively, moved around a little bit, just stay awake there, Kerstin, wake everybody up. But yeah, Alan was great. It was wonderful, good information.
It's good stuff. Thank you, Diane. And Michael and others who didn't have questions answered, the primary thing about today is getting you certified in this complimentary session. We'll get to as many of the questions that remain at the end that we can. Okay, probably won't get to all of them with almost 300 of you here today, but we'll get to as many as we can. Kerstin, welcome back, my friend.
Thank you. Let me try to share my screen now. Ah,
We see it.
okay. Unfortunately, I don't want to have to go through 100 slides. Let me.
Yeah.
Yeesh.
No, that's fine. And while
That is
you're doing
done.
that, folks, again, if you get bumped off, if you lose your internet for a second, you have a bad thunderstorm and you get booted off, just make the effort to try to come back as quickly as you can. We can see that on the timestamps on the sheets that Zoom provides afterwards. So I can see if you made the effort to come back in within a few minutes, or if you take a snooze for 45 minutes and then come back in. That's a different story. So don't worry about that if you get booted off and you come right back on. Don't worry. Don't be concerned about that.
All right, didn't get that done. Sorry about that, folks.
I love technology when it works the way you want it to.
Are you
There we
seeing
go.
that?
Choose from current slide.
Yeah. Well, if the mouse decides to work,
My fingers are
finger,
crossed.
either one. Not sure what it's doing.
And if you continue to have issues, I have mine ready to go. We'll give it a shot and see what happens.
Okay, there we go.
Sweet.
Oh, man. It keeps going back to this one. This can't be right. I'm sorry, folks. I guess I'll just manually go to section 3.
Okay.
Well, all right.
And while Kerstin's doing that, while she's getting to the page, remember too, you'll be getting your certificates to the email address that you used when you registered for the class. So and it'll take some time within the next 5 business days or so. So keep that in mind. It's not instant. Okay. You'll fill out your evaluation. We cross-check everything. I make sure you attended for the full time. So keep tabs on in the next few days, keep tabs on your spam folders, other tabs in your email platform, because sometimes these things end up in different areas that you're not accustomed to. So again, the next 3 to 5 days or so, by this time next week, if you think you attended in full and you think you should have a certificate and you don't find one, drop us an email and we'll investigate and get it done quickly. Kerstin, back to you. I see you got there.
Awesome. Thank you. All right. Thanks for your patience, everyone. Moving on. Topic 3. So we're going to talk about suspension and fining, and then transfer fees and estoppels. Okay. All right. The first topic is transfer fees, also referred to as application fees, okay? And this will apply if you have the ability in your governing documents to approve and disapprove sales, leases, and any other types of transactions. So the statute currently provides that if you have in your governing documents specific authority to approve or disapprove these types of transactions, as well as the authority to charge an application fee or a transfer fee in connection with the application, then you can do so. Okay. And the current statute sets the fee at $150 per applicant, other than husband and wife, or parent and dependent child who are considered one applicant. So this application or transfer fee is supposed to cover the cost of the background check that is typically required with an application for purchase or an application to lease a unit in the condominium. And so when we, as a practical tip, when we draft amendments to governing documents to authorize the board to approve, disapprove these transactions, as well as to charge this transfer fee, rather than including a specific amount in the declaration, such as $150, We just recommend, putting language, just giving the association the authority to charge this application fee at the highest amount permitted per law as amended from time to time. This way, when the statute changes and the fee is modified in the statute, well, you don't have to amend your declaration to conform to the new fee amount. The documents will just automatically adjust to the new rate. Now, if the application fees charged in connection with a lease, then the statute says if the lease or sublease is a renewal of the lease or sublease with the same tenant or subtenant or sublessee, then you cannot charge a new application fee. All right, security deposit. Also, if authorized in your declaration or bylaws, then the association can charge a prospective tenant a security deposit that would be held in an escrow account by the association. And the security deposit can be up to the maximum amount of the prevailing rent in the condominium. And essentially, that security deposit is intended to cover any damage to the common elements or association property that is caused by the tenant or the tenant's family members. And so you would use that deposit to cover any damage. And then obviously, if there's any damage in excess of that deposit, then you're going to have to seek additional reimbursement from the tenant and or the owner who is ultimately responsible for the tenant. All right, estoppel certificates. So estoppel certificates typically will come into play when an owner sells their unit at the condominium. What happens is, title company will typically get in touch with the association or management and request from the association certain information regarding the unit. Okay, so that is what we're talking about with these estoppel certificates. So if the association, whether through management or any director receives a request for this estoppel information from a title company, then you have to respond within 10 business days of receiving that request. Okay, the association has to designate on its website the person or entity with the street or email address for receiving the estoppel certificate request, and they must be completed either by a board member, authorized agent, or authorized representative of the association, which can include your property manager, even legal counsel. The estoppel certificates, when completed, they must be provided either by hand delivery, regular mail, or by email, and they must be signed by an officer or an authorized agent of the association. Now, in the next few slides, you'll see essentially the information. This is provided in the statute, and this is the information that needs to be provided in an estoppel certificate. So as you can see, here's the general basic information regarding the unit that is being sold. And then you'll have more specific information that you have to disclose in the latter sections of this statutory certificate. So here you'll see requests regarding assessment information. So basically, what are the regular or periodic assessments that are levied against the unit? The date of the periodic assessments that is paid through, what are the are there any special assessments due on the unit, etc. You want to make sure that if the owner is delinquent on any amount due to the association at the time of the sale of the unit, that you disclose it, right? Otherwise, you could be potentially in a position of waiving your ability to collect those unpaid assessments. All right, and then the estoppel also requests other information aside from assessments, including are there any transfer fees or any other fees that are due in connection with the sale of the unit? Are there any open violations of covenants or rules that have not been addressed at the time of closing? Does the association have a right of first refusal? Again, that has to do with the ability of the association to approve or disapprove a sale or other transfer. So if you have that ability, you would disclose that. You know, as a practical tip, you want to make sure that if there are any open violations that you disclose it on the estoppel, because again, if you don't disclose any open violations, you are potentially putting the association in a position of having waived that violation and not being able to then enforce it against the new owner. Okay. All right. The statute does allow the association to charge for completing these estoppel certificates, okay? It is a statutory sum. It is adjusted, but currently the sums that are set forth in the statute are here on this slide, okay? So these are the current rates. If the owner is not delinquent to the association, then you can charge up to $290 per certificate. If the owner is delinquent to the association, then in addition to charging the $299, you can charge an additional $179. If the estoppel request is being requested on an expedited basis, so if it's a rush, you can charge an additional fee of $119, but then you have to provide the estoppel certificate within 3 business days of receiving the request. And then if the association fails to deliver an estoppel certificate within the 10 business days of receiving the request, you are effectively preempted and cannot charge the fees outlined in this on the slide. On this slide, I've included basically the fee schedule if there are multiple units involved. Most likely this would not apply to your community, but here's the fee schedule. And as I mentioned, the fees that are specified in the statute will be adjusted every 5 years in an amount equal to the total of the annual increase for the last 5 years in the Consumer Price Index. And it is the Department of Business and Professional Regulations, the DBPR, that will adjust these rates. Okay, and then they will publish those new rates. So the estoppel certificates, if they are delivered by hand delivery or by email, then they are effective for 30 days. Okay. If the estoppel certificate is delivered by mail, then they have a longer period. They're effective for 35 days. Now, you cannot charge for an amended estoppel certificate, but the association can charge for a new estoppel, even if it's regarding the same transaction, if it is to be issued after the previous estoppel certificate expires. So there are instances sometimes where the closing date is postponed for one reason or another. If that happens and the certificate, the estoppel certificate expires and you need to reissue a new one, then yes, you can charge a new estoppel fee. All right, other requested information. Well, the association or their authorized agents can also charge a reasonable fee to a potential purchaser or a lien holder for providing good faith responses to additional requests for information, as long as the fee does not exceed $150 plus the reasonable cost of photocopying and any attorney's fees. So sometimes this will apply typically if an owner, if the purchaser is getting a mortgage on the unit, the lien holder will want to request some information pertaining to the condominium to see if whether or not they would lend money in connection with the unit. And so if you do receive a request from a lien holder, as the statute provides, yes, you can charge for reasonable fee for responding to that request, as well as attorney's fees if you do need assistance of legal counsel in responding to the request. Now, the statute also says that the association or its agent who does provide responses to these requests are not liable for providing information in good faith if you provide this disclosure in the response. So I've included here on this slide the disclosure, which is the responses herein are made in good faith and to the best of my ability as to their accuracy. So make sure any response contains this disclosure. All right, and then other documents that are typically seen in connection with a sale purchase of a unit include a condo question and answer sheet. This is a single page document. You can download it from the website of the Division of Condominium. And for those of you who are not familiar, the Division of Condominium is the governmental agency that governs condominiums in the state of Florida and regulates condominiums. And so you can Google Division of Condominium, go on their website, and there should be a tab containing forms, and you should be able to download this one-page form. This form needs to be answered. The questions on it need to be answered, and they include questions like, is leasing permitted at the condominium? Who qualifies as a board member? As a member. What are the assessments? And so every year you need to make sure that this form is updated, and then you keep it as part of the official records of the association. So certainly a potential purchaser is entitled to see the question and answer sheet. And then the seller also has a duty to provide to the buyer notice of all hidden defects. Okay. Oh, I just noticed these are actually Ellen slides. Okay, so there are some additional forms, and this includes the governance form. So in addition to other information the division considers helpful to a prospective purchaser, the governance form must address the following subjects. And again, this is something that you can obtain from the Division of Condominium website. The governance form will include basically the information that's on the slide. The role of the board members' responsibilities, the right of owners to attend and speak at board membership meetings, so forth and so on. So you can read what the governance form contains at your leisure. Okay. Let's move on to fines and suspension of use right. So in the next few slides, we'll discuss the fining and suspension of use rights for covenant violation. Okay, unrelated to owner being delinquent to on any monetary obligation due to the association. So under Chapter 718 of the Florida statute, the association can fine and suspend the rights of owners to use certain common facilities and amenities if an owner or their occupant, guest, tenant, or invitee is in violation of the governing covenants or rules and regulations of the association. Now, the authority does not have to be provided in the governing documents in order for you to be able to fine or suspend use rights, right? So the statute already gives you this particular authority. So if you don't see language in your declaration authorizing you to fine or suspend use rights, don't fret, okay? The statute gives you that authority. Now, the statute also says that in order to suspend and fine for covenant violations, it has to be done essentially in a two-step process. Okay, so the first part is that the board adopts the fine or suspension of use rights. And that typically is done at a duly noticed board meeting with notice of that meeting posted 48 hours in advance. And obviously you'll have to include as an agenda item the suspension of use rights or fining of the owner. And then once the board adopts the suspension or fine, you have to give the violating owner a notice indicating a date and a time that a committee is going to meet in order to confirm or deny that suspension or use right. Okay, and notice of that committee hearing has to be provided at least 14 days prior to that committee hearing. Okay, so that's where that 14-day notice comes in. Now, the hearing has to be held before an impartial committee of at least 3 individuals. And the role of the committee is limited to essentially determining whether or not to confirm or reject the fine or suspension of use right. The role of the committee is not to negotiate the fine. They're not there to determine if the fine should be less or more. It is essentially a yes or no vote. Okay? In terms of fines, the impartial committee first has to consist of at least 3 members who are not officers, they're not directors or employees of the association, or the spouse, parent, child, or sibling of director, officer, or employee of the association. The fine cannot exceed $100 per violation and may be levied on the basis of each day of continuing violation with a single notice and opportunity for hearing, but cannot exceed $1,000 in the aggregate. So let's take an example of a pet violation. If you're a condominium that prohibits pets, presumably you are enforcing this violation against all unit owners in a uniform fashion. And you've sent a demand letter to an owner to say, hey, you've got to remove the pet from the building. Each day that that pet remains at the condominium, okay, the board can impose a fine of up to $100, not exceeding $1,000 in the aggregate for that pet violation. Okay, so that's how that would work. Now, a fine cannot become a lien against the unit, and it is due within 5 days after the date of the committee meeting at which the fine was approved. So unfortunately, that is the current state of the law. You cannot recover the fine as a lien against the unit if the owner fails to pay. So what that means is that the fine essentially, remains reflected on the account ledger, and hopefully when the owner sells the unit, the fine will be reflected on that estoppel certificate that we talked about a few minutes ago, and then it gets paid at the time of closing. Okay. Okay. All right. Use right suspension. Now we'll shift gears for a minute and we'll talk about suspension of use rights, but for failure of the owner to bring their delinquency. Correct. Okay. So if an owner is more than 90 days delinquent on any monetary obligation due to the association, the board can suspend that individual's rights to use the common elements and certain common elements and facilities of the association. Now, the distinction with suspending use rights for non-payment as opposed to suspension of use rights for covenant violation for other than a monetary obligations is that you do not need a committee hearing in order to suspend use rights for delinquency. Okay, so this is something that the board can do by a board vote at a duly noticed meeting. Okay, doesn't need to go to a committee in order to ratify the vote. And then the use right suspension is effective until the monetary obligation is paid in full. Now, the suspension applies to any member and when appropriate to the member's tenants, guests, or invitees. And very important that the suspension specifically will not apply to certain areas. So really the suspension of use rights is intended to apply to your common facilities and amenities, such as your pool, your clubhouse, your tennis court, really any facility to which you have the ability to manage access and control access, right? So if you have the ability to turn off a fob, for example, to these amenities, then yes, this would be a viable remedy for you. If you don't have the ability to control access to these facilities or amenities, then obviously this remedy might not work for you. Okay. Now, what the statute does say is that the suspension specifically does not apply to limited common elements that are intended to be used only by that unit. So, for example, if a balcony or a patio is designated as a limited common element to the unit, well, you can't suspend use rights to that balcony. It also does not apply to common elements needed to access the unit. Okay, so you can't deny access to to a common walkway. It does not apply to utility services, parking spaces, or elevators. Okay. So in addition, the association can also suspend voting rights if an owner is more than 90 days delinquent in any monetary obligation due to the association. Now, monetary obligation, the way that it's defined in the statute, it includes not only regular and special assessments, it can include interest, it can include administrative late fees if you're authorized to charge them under the declaration. And it would also include any costs or attorney's fees that have been incurred in connection with the unit. So with suspension of voting rights, again, this is also something that the board can do without a committee hearing. So you would just need to post notice of the board meeting at which the suspension will be voted upon 48 hours prior to the meeting with a designated agenda item. Now, the statute does say that the delinquency has to be greater than $1,000. Okay, and then proof of the obligation must also be provided to the owner 30 days before the suspension takes effect. So not only does the owner have to be delinquent for 90 days, also the amount of the delinquency has to be more than $1,000. And you need to provide the owner with notice of the delinquency. So hopefully, since the owner's already delinquent, at some point you would have already provided the owner some kind of delinquency notice, or maybe even the notice of late assessment that's required under the statute before you begin collection. So hopefully the owner's already notified of the delinquency. Now, do want to point out that while the suspension of voting rights authority is in the statute, okay, it is in 718, case law has come out in a number of districts that essentially hold or have held that in order for the suspension of voting rights to be effective, the association needs to have the specific authority to suspend voting rights in the declaration, or the declaration needs to have what is known as Kaufman language. And Kaufman language refers to the magic words as amended from time to time that you will see sometimes referenced after Chapter 718 of the Florida statute in your declaration. So typically within the first couple of pages of your declaration of condominium, when you open it up, there should be somewhere there a statement to the effect of that this condominium or this association is governed and subject to Chapter 718 of the Florida statute. And then it might also say as amended from time to time. So if it does have language that says as amended from time to time, what that means is that substantive changes to Chapter 718 of the Florida statute, which affect vested rights of owners, will apply to the association. Okay. If you do not have Kaufman language, it means that substantive changes to the statute that affect vested rights of owners would not apply retroactively to the association or the condominium. And then the law that was in effect when the declaration was recorded is what would apply. Okay, So an example of this is a few years ago, the statute was changed to say that any amendment to your declaration that prohibits leasing or affects the term of leases would only apply to owners who vote in favor of the amendment, and then those who take title after the effective date of the amendment. Okay, that is an example of a substantive change that affects vested rights of owners. So the question is whether that particular change in the law applies to your community will depend on whether you have Kaufman or not. So what the courts are saying here is that the ability to suspend voting rights, which was a change in the statute, seems like they've taken the position that this is a change in the statute that affects vested rights of owners. And so you would only be able to suspend voting rights if you have Kaufman language in your declaration, or you've amended the declaration to expressly give you that authority. Okay. If you have any further questions on this, I know it's a very complicated concept of Kaufman. I strongly encourage you to speak with your legal counsel. All right, let's move on. So why are we talking about suspension of voting rights? Well, because there's the slide here tells you basically what the effect of suspension of voting rights has. So if voting rights have been suspended, the voting interest allocated to a unit or parcel may not be counted towards the total number of voting interests for any purpose, including the number necessary to establish quorum or the number required to approve an action. So what that means is, let's say you want to amend your declaration, okay? And the amendment requires the approval of a majority of the owners. Majority means 50% plus 1. And let's say in this example, the condominium has 100 units, okay? So if you've suspended the voting rights of, let's say, 10 delinquent owners, then the voting percentage that you need to get those amendments approved is a majority of the 90, not a majority of the 100. So 50% plus 1 of 90, not 50% plus 1 of 100. And of course, we'll talk about meetings in a moment. The first thing that you would have to do with any meeting in order for the meeting to proceed is to establish quorum. Quorum means, the minimum number of owners that have to be present at the meeting in order for the meeting to continue. For most condominium associations, quorum is a majority of the owners, 50% of the owners. So if you have suspended voting rights of 10 owners in a condominium that has 100 units, then the quorum that you need to establish would be 50% plus 1 of 90, not 50% plus 1 of 100. Okay. All right, so let's shift gears and tackle budgets, reserves, and financial reporting. All right. So most of you are probably aware that every year the association board has to adopt an annual budget of your estimated revenues and operating costs, as well as reserves for the upcoming fiscal year. Okay, many of you are just finished their budget season, or maybe you're still in the middle of budget season and in the process of adopting your budget. So hopefully these will be helpful and useful in adopting a budget. So here are some line items that you'll typically see in an association budget. These are typically the minimal line items that you would see. Of course, you might have way more than this, but these are pretty basic, right? So you might have a line item for administration, management fees if you are managed by property management company, certainly all maintenance and repair of your common elements and association property, taxes, insurance, professional expenses. If you have legal counsel, hopefully you do, that would qualify under professional expenses, or if you needed to have retained an engineer, that would go there. Security, if you provide some form of security guard security guard or concierge service to your condominium owners, reserves, and then again, you might have additional expenses. Now, the statute does provide for the process of adopting your budget. Certainly, you might have additional provisions in your bylaws. If you have more restrictive requirements for adopting the budget in your bylaws, certainly you'll go with that. Otherwise, the minimum requirements for adopting a budget are that you have to provide 14 days notice of the meeting at which you're going to adopt the budget to all owners. And along with that notice, you have to also provide a copy of the proposed budget. So that notice of the meeting at which you can adopt the budget has to be either hand delivered, it can be mailed, or it can be electronically transmitted, meaning via email to any owner who has consented to receiving notices by email. Now, you are required by statute to also execute an affidavit of compliance with the notice requirements. And then you would just keep the affidavit as well as a copy of the notice and the budget as part of the official records of the association. Now, if you make any changes to the budget during a properly noticed board meeting, okay, you don't need to resend or re-notice that budget meeting. Okay, remember the budget is just an estimate, so you can discuss the budget at the board meeting, and if you need to tweak the numbers, you certainly can without having to re-notice or resend the budget. Effective July 1st of 2021, the statute was amended to read that the board is required to adopt the annual budget at least 14 days prior to the start of the association's fiscal year. So what is your fiscal year? Well, typically the bylaws will indicate what the fiscal year is. For most associations, it's probably a calendar year, but if you're not sure, go ahead and check your bylaws. And then the statute also provides that in the event the board fails to timely adopt an annual budget a second time, it is deemed a minor violation, and the prior year's budget continues in effect until the new budget is adopted. All right, so we've talked about the budget and the components that you saw in the earlier slides typically are your operating expenses. So that would be in the operating section of the budget. You're also required to have a budget that contains a reserve schedule. Okay, now we've identified here the definitions for capital expenditures and deferred maintenance, which is what you will be maintaining statutory reserves for. Now, some examples of statutory reserves include, in addition to the 4 basic ones, okay, which we'll talk about in the next slide, might include balcony restoration, sidewalk improvement, seawall replacement, air conditioning replacement, as well as potentially elevator modernization, right? Those things are not cheap. So what the statute says in terms of the reserves that you have to fully fund every year, they include, at a minimum, reserves for roof replacement, building painting, pavement resurfacing, and then any other item that has a deferred maintenance or expense or replacement cost that exceeds $10,000. So those are the primary statutory reserves that every condominium in the state of Florida has to fully fund every year. Now, I'm not talking about your CEUs reserves, which is what Alan discussed. Okay, CEUs reserves apply for only particular condominiums. These reserves that I'm discussing apply to every condominium, whether you're 2 stories or 15 stories, okay? These requirements did not go away when the statute was changed to include CEUs. So every condominium, even those that are 3 stories or higher, need to maintain these regular reserves. Now, computing these reserves, well, they're based on a formula, right? And the Florida Administrative Code provides what the formula is, as well as tells you what the reserve schedule needs to include. So the formula is going to be based on the estimated remaining useful life, and then the estimated replacement cost or deferred maintenance expense of each reserve item. Okay. So unless you're maintaining pooled reserve accounts, and we'll talk about pooling in a minute, your reserve schedule at a minimum has to include these items that are in the bullet point, right? Your total estimated useful life of the asset, the estimated remaining useful life of the asset, the estimated replacement cost, and then the estimated fund balance as of the beginning of the period for which the budget will be in effect. If you are pooling reserves, your reserve schedule has to be essentially substantially similar to this. And the Florida Administrative Code provides exactly what the reserve schedule needs to include. Okay. All right. So, you know, hopefully a lot of you have an association accountant. Definitely recommend you getting together with the association accountant to make sure that your budget and reserve schedules are properly done. We have certainly handled complaints from owners that were filed with the Division of Condominium based on failure to properly create a budget. And so definitely get with your accountant for that. Now, for reserves, waiving and reducing reserves. So every year, the association has to fully fund the reserve items that I just mentioned, right? Now, for non-SERS reserves, okay, the statute still allows owners to vote to whether to waive or partially reduce the funding of these reserves. Okay. Whether or not you as a board want to give owners the option to waive or partially fund these statutory non-SERS reserves, well, that is discretionary. That is a business decision, right? But if you do think that, you know, reserves should be waived or reduced for the coming year, it is something that owners have to vote on. So that is not a board decision. The board decision is whether or not to give owners the option to waive or reduce funding. Once you've decided on giving the option to the owners have to approve the waiving or the reducing of reserves. So the vote that you need to get is now the vote of the majority of the voting interest. It used to be that you only needed to get the vote of a majority of quorum. That voting threshold was now increased a couple of years ago. So now you need the approval of a majority of the voting interest, okay, in order to either waive or partially reduce reserves for the coming year. If you do get the necessary vote of the owners, then note that this vote is only applicable for the budget year in which the vote was taken. Okay, so that means that if every year you want to give owners the option to waive these non-SERS reserves, then every year you need to get that vote. So it's not just one vote for the next decade. Nope, every year you need to get that vote. If at the meeting no waiver or reduction in reserves is achieved or a quorum is not attained, then fully funded reserves go into effect. Okay, now as a practical tip, right, because the board has to adopt a budget with a reserve schedule, right, you will want to have a membership meeting first. If you're going to give the owners the option to waive or partially fund reserves, you want to have that membership meeting first so you can tally the votes, okay, before you have your budget meeting to adopt your annual budget, right? This way, once you know what the vote is from the membership meeting, you as a board can then say, okay, it looks like we'll be adopting a budget with fully funded reserves, or nope, looks like the owners approved waiving reserves. So we'll be adopting a budget with waived reserves. So you can have the membership meeting and the board meeting. You can have the membership meeting on the reserve issue and then the board meeting to approve the budget on the same date, one immediately following the other, or you can do them, on separate days, as you prefer. Now, with reserves, with statutory reserves, they are limited for the particular purpose for which the reserve was established, right? So roof reserves can only be used for replacing roofs. Painting reserves can only be used for painting. So you're not allowed to use statutory reserves for alternate purposes unless the statute says you get a vote of a majority of the voting interest. So let's say you've been properly maintaining these statutory reserves, and let's say you have to replace the roof of the building. Okay, it's a must. You got to do it this year, but you haven't really you haven't achieved the fully funding of that roof replacement because perhaps over the years you've been waiving reserves, and you want to dip into the painting reserve. Okay, well, the only way that you can use the reserve monies that have been allocated for painting for roof replacement is if you get that membership vote. Again, this does not apply to your CEUs reserves, okay? You're no longer allowed for any budgets adopted after December 31st of 2024, you're no longer allowed to use you're not allowed to use CEUs reserves for alternate purposes. This is only for non-statutory reserve, CEUs reserves. Now, pooling, Alan might have briefly touched on this. Pooling has to do with setting up reserves for, 2 or more reserve items. Okay. The statute does allow pooling, or the statute is silent on pooling. It doesn't expressly prohibit pooling, which means that associations may pool reserves. Now, if you are looking to pool existing reserves, right, and transferring money from these non-pooled accounts into a pool account, yes, you will require a vote of the members to do that. Now, the benefit of pooling reserves is that, let's say you pooled reserves for your roof replacement, your building painting, and your paving. And again, with the scenario that you need to replace the roof, but you don't have enough money that's allocated to the roof, and you want to take some from monies allocated for painting. Well, with a pooled reserve account, you would be able to use monies reserved for painting to do the roof replacement without a vote of the membership, right? Because it is within the pool. I mean, eventually we'd have to replenish that money, and that's more of an accounting issue that you're going to have to discuss with your accountant. But again, it gives you that flexibility. All right, if you do decide to give owners the option to waive or reduce the funding of reserves for a given year, then the limited proxy and the ballot that you give owners to vote on this particular issue have to include this disclosure, and this comes straight from the statute, which is waiving of reserves in whole or in part, or allowing alternate use of existing reserves may result in a unit owner liability for payment of unanticipated special assessments regarding those items. So you have to let the owners know that, hey, while we're giving you the option to waive reserves or reduce the funding of reserves, if you do that, and we need money to address any of these reserve items, you could be subject to a special assessment. All right. So let's shift gears to financial reporting. The statute provides that within 90 days after the end of the fiscal year, or annually on the date that is specifically provided in the bylaws, the association has to prepare a financial report of preceding fiscal year. And then within 21 days after the financial report is completed, but no later than 120 days after the end of the fiscal year, the association has to mail or hand deliver to each owner a copy of the financial report And then the statute was changed last year to provide, and you also have to provide a notice that a copy of the most recent financial report is available and will be provided free of charge within 5 business days of receiving a request. Now, the statute used to read that you had to do one or the other. You either provide a copy of the financial report within these timeframes, or you have to provide notice that the financial report is available and will be provided upon request. For some reason, the statute was modified last year to include and instead of an or. Seems like this was a scrivener's error, and hopefully this will be addressed in the next legislative session. Okay. The association also has to provide an annual report to the department containing the names of all of the financial institutions with which it maintains accounts, as well as a copy of such report may be obtained from the department upon written request of any association. Now, in terms of the level of financial reporting, well, the level of financial reporting is going to be based on the total annual revenue of the association, unless, of course, you have a specific requirement in the bylaws to do an audit. If your bylaws specifically require you to do a financial audit, you have to do the financial audit regardless of what your annual revenue is. If your bylaws do not specifically require the audit, then your level of financial reporting will depend on your annual revenue, and the statute tells you what that report has to be based on these dollar thresholds, right? So for example, if your total annual revenue is at least 300 but less than 500, by statute, you're only required to prepare reviewed financial statements. If your total annual revenue is $500,000 or more, then by statute, you have to do an annual audit. Now, the members, the statute does say that owners can vote to reduce the level of financial reporting. Okay, but you cannot reduce this level for consecutive fiscal years. And this was one of the changes that took effect July 1st of last year. Okay, so that was topic 3. We'll move on to topic 4, where we'll talk about notice and meeting requirements, insurance requirements, and then conflicts of interest, and then we'll be done. And that took almost an hour, so we're good in timing. Okay. We'll talk about membership meetings first. So before I talk about membership meetings, let me just kind of backtrack a little bit and just generally reference meetings, because I hear this all the time. The association is having a meeting. There are 2 major meetings you're going to have, 2 classes of meetings, right? It's either going to be a board of directors meeting, which is a meeting at which the board votes and takes action, or you're going to have a membership meeting. And a membership meeting is one at which owners vote. Okay? So depending on whose votes, that is how you're going to classify your meeting. There is no association meeting. It could be a meeting of the membership of the association, or could be a meeting of the board of directors of the association. Now, within the umbrella of membership meetings, there's 2 types of membership meetings. There's the annual membership meeting, and that is the one, if nothing else, that is the one and only meeting that you're going to have every year, because it is at that meeting that you conduct election of directors. Okay, that's your annual meeting. Any other meeting of the members in that year, other than the annual meeting, will be called a special membership meeting. Okay, so with regards to the annual members meeting, the annual members meeting has to be held at the location provided in the bylaws, and if the bylaws are silent, then the meeting has to be done has to be conducted within 45 miles of the condominium. Certainly, the membership meetings have to be held at a location accessible to a physically handicapped person if it's requested by the physically handicapped person. And your election has to be conducted on the date of the annual meeting, and Alan already talked about elections. Now, special membership meetings, again, refer to meetings other than your annual meeting. They have to be held when called by the board or upon the written request of at least 10% of the unit owners, unless a different percentage is provided in the governing documents. As with any meeting, you're going to provide notice of membership meetings, which have to include an agenda. So you're going to include the date, the time, location of the meeting, and then include agenda of your membership meeting. And then it has to either be mailed, hand delivered, or electronically transmitted to owners at least 14 days before the meeting, unless of course your documents, your bylaws provide something else. Your bylaws require a longer period, then you go with that. Otherwise, the minimum period is 14 days. You also have to post notice of your membership meetings, and you have to adopt a rule designating the specific location on the condominium or association property where meetings will be held. If you're mailing notice, that notice has to be mailed to each owner at the address that was last furnished to the association. Proof of notice has to be provided by an affidavit. Basically, the officer or individual that provided the notice attests that the notice was properly provided. And then in lieu of or in addition to the physical posting, the board may, by reasonable rule, adopt a procedure for posting and repeatedly broadcasting notice and the agenda of the meeting on a closed circuit cable television system serving the association. Now, for those condominiums that do have a bulk cable contract, okay, and you have bulk cable and this option of a closed circuit cable television system, perhaps this could be an option, okay? So we just discussed that association can provide notice by electronic transmission to those owners who have consented to receiving notices electronically. And typically that would be via email. Electronic notice can only be sent to unit owners who consent in writing. So the consent can be sent by email to the association, but you have to have written consent from the owner. So if an owner has not consented to receiving notices electronically, well, you're going to have to use these other methods of providing notice to this owner, which would be the official notification to them. You can send them notices electronically as a courtesy, but that would not constitute as official notice, which means that that owner can potentially, legally challenge if you didn't give them proper notice in one of the other ways. Just note that electronic notices cannot be used for recall of a board member or for noticing a membership meeting at which the owners are going to vote to forego retrofitting. And notice of a meeting is effective when sent by the association, regardless of when the notice is actually received by the owner. And then note that if you do consent, if an owner does consent to receiving notices by email, I think this is in the next slide, those email addresses, right, or if they consent to receiving notices by fax, that email and fax number, that becomes accessible to other owners. So if an owner makes a request for access to official records for specific email addresses, well, if an owner consented to receiving notices by email, yes, you have to provide access to those emails. Okay, Alan talked about websites, right? So the new requirements for website goes into effect January 1st of 2026. But for those of you who are under the current website requirements with 150 units or more, the association also has to post digital copies of notices of membership meetings on the website. Okay, and you got to post notice of those membership meetings at least 14 days prior to the meeting. And then you also have to post on the website any document that is associated or related to that noticed meeting, right? So for example, if owners are approving amendments at that meeting, then you have to post the notice along with a copy of the amendments at least 7 days before the meeting. If you currently do not fall under these website requirements, but you do maintain a website, then certainly suggest that you also post notice and these documents on the website. Quorum, again, quorum is the minimum number of owners that need to be present at the meeting in order for the meeting to proceed, right? So unless there's a lower number provided in the bylaws, quorum for membership meetings is going to consist of a majority of the total voting interest. And then unless otherwise provided in the Florida statute or in the governing documents, decisions to be made by members have to be made by a majority of the voting interest represented at a meeting at which a quorum is present. What this means is, let's stick with the example of a condominium with 100 units. A majority of the voting interest represented at a meeting at which a quorum is present means first you have to establish quorum. And let's say your quorum is a majority. So that's 50% plus 1 of 100. So that's 51. Assuming that 51 owners is the minimum number of owners that showed up at this meeting, whether in person or by proxy. Majority of quorum would be a majority of those 51 owners. Not a majority of the 100, but majority of the 51 owners that are actually present and voting at that meeting, if that's the minimum number of owners that show up. Now, obviously, the more owners showed up, the higher this voting threshold will be. So if 60% of the owners show up at this meeting in person or by proxy, then you would need to get a majority of those 60%, affirmative vote from a majority of the 60% in order for this particular action to pass. Okay, that's what that means. Written consent. Written consent is an option for owners to consent to a particular issue in lieu of having a membership meeting. So we talked about voting at a meeting. Well, if you have specific authority, and typically this would be in the bylaws, for owners to vote by written consent, then that means that you can dispense with having a membership meeting. So you don't have a membership meeting, and instead you provide owners with basically a memorandum or a letter letting them know what the action is that you want them to take. In this case, in this example, let's do the amendments. Here's amendment to section 5 of the declaration that we want to amend to prohibit pets. If you're in favor of it, right, then you're going to include a consent form. Basically, if you're in favor of it, please sign at the bottom of this form attesting to your consent, and then return it to the association. So that is the consent form. Okay. Those consent forms are essentially from the first executed consent form, you have 90 days to then get the membership vote that you need. Okay, so it's like a proxy where these are good for 90 days. And if you get the membership vote that you need in the time frame, then the action passes. Okay. But again, you need specific authority in your bylaws to authorize owners to vote by the written consent process. All right, members have the right to speak at membership meetings with regards to all agenda items. And the association may, if not already done so, adopt rules regarding the frequency, the duration, and the manner of member statements. A member may record or videotape also meetings of the members, as well as board meetings, which we'll talk about momentarily, so long as they are subject to the rules adopted by the division. And I've included here some of the rules that the division has adopted, which are in the Florida Administrative Code. Now, owners can vote by general or limited proxy. Limited proxies and condominiums, though, do have to, they have to be used for very specific things, such as voting to waive or reduce reserves, vote to waive any financial reporting requirements, voting on any amendments to the governing documents, and then any other matter for which the condominium requires or permits the votes of the unit owners. With limited proxy, essentially, you will be including on the proxy the specific action. You'll identify the specific action that the owners are voting upon, and the owner gets to check off yes or no, for or against, however you pose the question, and then they sign the limited proxy, and then they return it to the association in advance of the meeting. Unless, excuse me, unless a limited proxy is required, a general proxy may be used in voting for non-substantive changes. Proxy, whether it's limited or general, cannot be used to vote in an election or to vote to forgo retrofitting. So Ellen, I'm sure already explained. Can't give a proxy to someone else to then have that individual vote your election ballot. That doesn't work. That is not in conformance with the statute. The proxy is in effect only for the specific meeting for which it was originally given and any adjournment of the meeting, and essentially expires 90 days from the date of the original meeting. And then every proxy is revocable at any time at the pleasure of the member who executed. All right. Shifting to Board of Directors, notice and meeting requirements. So officers and directors have a fiduciary responsibility to the unit owners and must act reasonably. Okay, so that means that you have to exercise your best efforts, your best business judgment. And guess what? You're not an expert in condominium law, right? Nobody expects you to do that. So yes, you are, however, expected to rely on the advice of the expert, right? Your legal counsel, your insurance agent, your engineer. Okay, these are the professionals that are licensed and practice in this area of the law and in this area. And so, yes, you are expected to rely on their guidance and advice in your day-to-day management and operation. Now, directors must not be compensated unless otherwise authorized in the bylaws. And unless otherwise provided, the corporate powers of a corporation are exercised by the board, right? So that means that no board member, not even the president, should be making unilateral decisions, right? Unless, of course, these powers have been delegated to a specific officer or in the event of an emergency. All right, kickbacks. An officer, director, manager may not solicit, offer to accept, or accept a kickback. And a kickback has been defined in the statute to mean anything or service of value for which consideration has not been provided for an officer, director, or manager's own benefit from any person providing or proposing to provide goods or services to the association. So like Alan mentioned, basically anything that any value that you obtain from a third party for which you have not paid consideration, that is essentially a kickback. An officer, director, or manager who knowingly solicits, offers to accept, or accepts a kickback commits a felony in the third in the third degree and must be removed from office. However, there is no prohibition against an officer, director, or manager from accepting services or items received in connection with trade fairs or education purposes. And then the statute was amended last year to now prohibit the use of debit cards issued in the name of the association. A director or officer who's charged by information or indictment with any of the following crimes must be removed from office. And we've identified these crimes here: for forgery of a ballot envelope or voting certificate, theft or embezzlement, destruction of or refusal to allow inspection or copying of the official records, obstruction of justice, and any criminal violation under the Condominium Act. And then the board must fill the vacancy until the end of the suspension period or the end of the director or officer's term, whichever occurs first. And then a director or officer who has such charges pending may not be appointed or elected to a position as a director or officer of the association and may not have access to the official records except pursuant to court order. So how do you get off the board? Well, there are 6 ways. You can certainly resign in writing. You can be recalled. And a recall is a process by which the owners vote to remove directors. If you're delinquent in the payment of any monetary obligation due to the association for more than 90 days, yep, you're deemed to have abandoned your seat, which creates a vacancy. Criminal charges involving theft or embezzlement of association funds will certainly get you kicked off the board. For knowing and willing violation of the Condominium Act, the division may also order removal of the officer or director, and then failure to satisfy your certification requirements, which is why you're here. You will be suspended until you comply with your certification requirements. Now, a few changes that went into effect July 1st of 2024 is that in a residential condominium association of more than 10 units, well, the board is now required to meet at least once each quarter. So you can't just meet once in the beginning of the year and call it a day. Nope, you need to have a board meeting at least once each quarter, so at least 4 meetings. And at least 4 times each year, the meeting agenda has to include an opportunity for members to ask questions of the board. Okay, the statute doesn't say that this has to happen each quarter. It just says 4 times each year. Now, at times, the board can take action outside of the context of a properly noticed board meeting, such as in the event of an emergency. If that happens, you have to still ratify that action that was taken outside of a duly noticed meeting, and you would ratify it basically at your next board meeting. Now, board members can use email as a means of communication, but you cannot cast a vote via email. Okay. Now, in terms of notices of board meetings, typically, unless your bylaws provide for other notice requirements, most board meetings just require a 48-hour posted notice of the date, time, location, and agenda items, except for 2, which are specifically in the statute require 14-day notice. And those are meetings at which the board is going to adopt a non-emergency special assessment, and then meetings at which you can adopt a rule regarding unit use. Those 2 types of meetings require you to either mail, hand deliver, or electronically transmit notice of the meeting at least 14 days prior to the meeting. And then you also have to post notice of that meeting at least 14 days prior to the meeting. Where you need to put post notice, again, the board has to adopt a rule to designate the specific location where notices will be posted. And then for those associations that do have a bulk cables contract and have a closed circuit cable television system, you also have this option of posting and broadcasting notice and agenda prior to the meeting. Again, for those associations that are currently subject to the website requirements, if you have the website, then you have to post copies of all board meeting notices, either 48 hours or 14 days prior to the meeting. If you're not currently under the website requirements, but you have one, certainly recommend you do so as well. Board meeting agendas, all notices have to identify agenda items. Now, if an item is not included on the agenda, it may be taken up on an emergency basis at that board meeting by a vote of at least a majority plus one of the board members who are present at the meeting. Okay. However, if you do take up an item at the meeting on an emergency basis, you still have to ratify that decision taken at that board meeting at your next board meeting. If 20% of the voting interest petition the board to address an item of business, then the board has within 60 days after receiving the petition to place that item on the agenda of its next meeting. And then another change that took effect July 1st is that if an agenda item relates to the approval of a contract, well, a copy of the contract must be provided with the notice, and then it has to also be made available for inspection and copying upon written request of the owner. Okay. So if you're adopting a contract or proposal, however you want to call it, a copy of that contract proposal needs to be included with the notice. Now, if you're going to be adopting a special assessment, then the statute says that notice of the meeting at which you're going to adopt a special assessment has to include state that assessments will be considered. You have to include the estimated cost of the special assessment and then provide a description or the purpose of the assessment. Meetings of the board at which a quorum of the board is present must be open to all owners with the exception of two types of meetings, and those include meetings between the board and the association's legal counsel with respect to proposed or pending litigation. If the meeting is held for the purpose of seeking or rendering legal advice, and then meetings held for purposes of discussing personnel matters. Those can be closed. You would still notice the meeting, so you would still include the date, time, location of the meeting, but you would put at the top, closed meeting with legal counsel or closed meeting to discuss personnel matters. And then board meetings, just like with membership meetings, owners do have the right to tape record and videotape these meetings subject to reasonable rules adopted by the division, which we've included them here straight from the Florida Administrative Code. Owners also have the right to speak at board meetings with reference to all designated agenda items. And then another change that took effect July 1st of 2024 is that owners also have the right to ask questions now relating to reports on the status of construction and repair projects, the status of revenues and expenditures during the current fiscal year, as well as any other issues affecting the condominium. However, if not done so already, recommend that the association adopt written, reasonable rules governing the frequency, duration, and then a manner of member statements. In terms of quorum for the board, a majority of the board present at a board meeting constitutes a quorum. And then directors can appear at meeting by telephone or video conference, via Zoom, or any other, virtual, platform, essentially. So long as you can hear the directors, their presence via any of these electronic means will constitute towards quorum. And yes, they can also vote, via these platforms or via the phone. Unless otherwise provided in the Florida statute or the governing documents, the action of a majority of the directors present at a meeting at which a quorum has been attained constitutes the action of the board. Now, directors may not vote by proxy or by secret ballot at board meetings, with the only exception that they can elect officers by secret ballot. Okay. And by secret ballot, I mean, you can literally take a Post-it and write the name of the officer that you're voting for, and that would be sufficient. All right, committee meetings. Meetings of a committee to take final action on behalf of the board or to make recommendations to the board regarding association budgets are always subject to meeting notice requirements. They cannot be exempted, right? So you would notice these committee meetings just like you would any board meeting. Now, if we're talking about meetings of committees that do not take final action on behalf of the board or do not make recommendations to the board regarding association's budget, those specific committee meetings can be exempted from the notice requirement only if the bylaws specifically exempt these meetings from notice requirements, which means most bylaws, especially the older ones, do not contain this exemption. So that means you have to amend your bylaws to give you that exemption. Okay, so yes, that means that these, remember when we talked about fining and we talked about suspension of use rights for covenant violations, you need a committee, right, to ratify or deny that fine or suspension. Yes, so those committee hearings have to be duly noticed. Okay. Okay, we're almost at the end. I think we have just insurance and conflict of interest, and we are almost at the let's see, it's 2:30, so we're getting there, folks. Stay with me another 20 minutes or so, and then we're done. Okay. So associations have to use their best efforts to obtain and maintain adequate insurance to protect the association property, and common elements. Now, what is adequate insurance? It has to be based on the replacement cost of the property to be insured as determined by an independent insurance appraisal. And that replacement cost must be determined at least once every 36 months. So basically, every 36 months, you need to have an appraisal done to determine what is the adequate property insurance that you need to maintain for the condominium. Now, the association should also have liability insurance for directors and officers, okay, as well as insurance for the benefit of association employees. So that is referred to as directors and officers insurance, D&O coverage, and essentially that would cover errors and omissions of directors and officers. So if you are negligent and in some way, and a claim for negligence is made, or a claim for breach of fiduciary duties made against the board of directors, this is the insurance it's going to cover. It's the directors and officers insurance, not the liability or the property insurance, not likely. Okay, so please get with your insurance agent, make sure you have this coverage. Even though it's not required by statute, it is highly recommended if you're on the board. Okay, this is to protect you. And then certainly flood insurance for common elements and association property. That is going to be dependent on whether or not you're in a flood zone. Okay. You are also required to maintain what is known as fidelity bond coverage. Okay. You have to maintain adequate fidelity bond coverage for all persons who control or disperse funds of the associations. So what does that term mean? Persons who control or disperse association funds? Well, it includes, but not limited to, individuals who are authorized to sign checks, the president, the secretary, the treasurer, and certainly property management as well. Now, the insurance or fidelity bond coverage has to cover the maximum funds that will be in custody of the association or its management agent at any one time. And obviously, the association is the one that bears the cost of the bonding. So it is a common expense. Now, effective July 1st of 2024, if the division receives a complaint, the division will monitor an association for compliance with the statutory insurance requirements and may issue fines and penalties established by the division for failure of an association to maintain required insurance. Now, what is the responsibility of the association to insure what property? Well, for any policy that is issued or renewed after January 1st of 2009, the coverage has to provide primary coverage for all portions of condominium property as originally installed or replacement of like kind, as well as any alteration or addition made to the condominium property. So essentially, this covers condominium common elements, right? It does not cover specific items that are within the unit. So effective July 1st of 2010, the ability to force place a unit owner's coverage requirement was eliminated. So the statute specifically says that the association's insurance requirements exclude the following items, right? And I've put them here. This comes straight from the statute. So association insurance does not cover these items: personal property within the unit, wall, ceiling coverings, electrical fixtures, appliances, water heaters, water filters, built-in cabinets, curtains, drapes, window treatments, or replacement of any of that, okay? This is excluded from association coverage, which means that this is the responsibility of the unit owners to maintain insurance on. The problem is that the statute does not require owners to maintain insurance for these items. Okay? And so the association cannot require owners to maintain this, nor force place insurance coverage for that. That was eliminated July 1st of 2010. So the only way to force owners to maintain insurance on these items would be through an amendment to your declaration of condominium. Now, whether or not that is an appropriate or even beneficial amendment for your particular condominium, speak with your legal counsel on that. Owners are responsible for the cost of reconstruction of any portion of the condominium property for which property insurance and the cost of any such reconstruction done by the association is chargeable to the unit owner, okay, and may be enforced as an assessment. Now, in the event of a casualty event, any portion of the condominium property that has to be insured by the association, which is damaged by an insurable event, such as, fire or, hurricane, it has to be reconstructed, repaired, or replaced by the association as a common expense. Okay, so if there was damage to the common elements by an insurable event like a hurricane, and there was damage, well, that is on the association to repair or replace as a common expense. So drywall would be included in what is considered common elements. Okay. Now, unit owners are responsible for the cost of reconstruction of any portion of the condominium property for which owners require to maintain property insurance. So anything that's within the unit, right? In this last slide, that's what they would be responsible for reconstructing in the event of casualty, as well as any portion of the condominium property not paid by insurance proceeds if the damage is caused by the intentional conduct, the negligence, or failure of the owner to comply with the governing documents. Okay. And then the cost of any reconstruction work that's undertaken by the association for the items that the owner would have been normally responsible, well, that can be charged to the owner as an assessment. With this slide, just note that if we're not talking about an insurable event, one that would be covered by insurance, then essentially, the responsibility of the association and owners for repair and replacement, that's going to be determined by your declaration. So you'd have to look at the maintenance section of your declaration to see who's responsible for what when damage is caused by a non-insurable casualty event. All right, and then the last topic, conflicts of interest. So we can get this done in the next 5-7 minutes. And then we're done, and I will take some questions at the end. All right, board of directors, conflicts of interest. So directors, officers, and relatives of directors and officers must disclose to the board any activity that could be construed as a conflict of interest. Well, the statute says that there is a rebuttable presumption of a conflict of interest if either of these events occur. Either the director, officer, or relative of a director and officer enters into a contract for goods or services with the association, or these individuals have an interest in an entity that is looking to conduct business with the association. Okay, that is what a conflict of interest is. And the statute doesn't necessarily prohibit the association from entering into a contract with that is subject to a conflict of interest, but it does require you to follow certain statutory procedures in order to properly have that contract or transaction approved. So if a director, an officer, or relative of a director or officer proposes to engage in an activity that is a conflict of interest, that activity has to be listed on all the contracts, transactional documents related to the activity, and has to be attached to the meeting notice and agenda. Then at that board meeting, the approval of the contract or the transaction requires a vote of 2/3 of the directors who are present, of the non-interested directors, right? The director, officer, or the relative of the director, officer who is subject to this conflict of interest can attend the meeting at which the board will be voting on, and is authorized to also make a presentation to the board. But then after the presentation, that director, officer, or relative has to then excuse themselves from the meeting. Now, their presence at the meeting does count towards a quorum. And by them removing themselves from the meeting, that does not reduce the quorum requirement, right? So they have to leave the meeting following the presentation, and then the board votes and needs to vote by 2/3 of the board in order to approve this transaction. Let's see, okay. Now, if the board votes against the proposed activity, the director, officer, or relative must then notify the board in writing of their intent not to pursue the proposed transaction, right? Or they have to withdraw from office. Now, at the next meeting of the membership, whether this is your annual or this is your special membership meeting, the existence of the contract transaction has to be disclosed, right? And then upon a motion of any member of that membership meeting, the contract or transaction may be canceled by a vote of the majority of the members who were present at that meeting. So that means that even though the board approved the contract or the transaction that is a subject of a conflict of interest, the membership does have the option to cancel that contract or that transaction by vote of a majority of the members present. Now, if the association has to cancel the contract because the membership voted to cancel it, well, the association would not be liable for any liquidated damages or any cancellation, termination fees that could be, in the contract. The association would only be responsible basically for services or goods provided up to that point of cancellation. And then a contract that is entered between director, officer, or a relative of these individuals with the association that has not been properly disclosed as a conflict of interest is voidable and then can be terminated upon filing of a petition that is signed by at least 20% of the voting interest. And then for those associations who are subject to the current website requirements, yes, you have to post a copy of the document or the contract that is the subject of the conflict of interest. And then there is also a similar statute regarding conflicts of interest involving the community association managers or management firms. So essentially, if the property manager or the management firm wants to enter into a contract with the association, or any relatives of these individuals want to enter into a transaction or contract with the association, or if the property manager or the management firm owns an interest in another entity that is looking to enter into a contract with the association. And that's not uncommon. Sometimes management firms have interest in other entities, for example, a maintenance company or a landscaping firm, and they want to provide service to the association. Well, there is a rebuttable presumption that there is a conflict of interest in that particular contract or transaction. So there is a statutory process for proving those contracts, which is very similar to what I just discussed with board of directors conflict of interest. Essentially, the contract again has to be disclosed on the notice and the agenda of the meeting at which the board has to approve it. And then that transaction that is the subject of the conflict of interest ultimately has to be approved by an affirmative vote of 2/3 of the directors who are present. And then at the next membership meeting, the existence of this conflict of interest has to be disclosed to the members, who get to basically, disapprove the transaction. If the manager or the management firm has previously disclosed the conflict of interest in an existing management contract between the association and the firm, the conflict of interest does not need to be additionally noticed and voted during the term of the management contract, but upon renewal, it must be noticed and voted on in accordance with these requirements. And then if the board finds that the management firm or the property manager has violated this section, did not properly disclose the conflict of interest, then the association can cancel the management contract. And if it cancels the management contract, the association's not liable for it's only liable for the value of management services provided up to the time of the cancellation. And it wouldn't be liable for any termination fees or liquidated damages or other penalties for canceling early. And then the statute does also provide that failing to disclose any conflict of interest constitutes grounds for which disciplinary action can be taken against the management firm or the property manager. Okay, and I think that concludes it.